Good morning, sir.
Morning, Mr. Blake.
So this morning we're going to hear from Mr. Coyne and Miss Helliwell. As you know, we finished today at 2 o'clock, so the plan is to take two breaks, two 15-minute breaks every hour and a half or so. There will be a fire alarm at 10 o'clock today. The plan is for us to put our hands over our ears rather than to leave the room.
Yeah, fine.
And there won't be any lunch. Everybody will take their lunches at 2 o'clock.
Yeah, that's fine, Mr. Blake.
Thank you very much. I'm going to call Mr. Coyne, please.
Repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much. Can you give your full name, please?
Jason Peter Coyne.
Mr. Coyne, you should have in front of you a witness statement dated the 16th of May 2023. Is that correct?
Yes, I do.
Thank you. And if you turn to page 16, is that your signature?
Yes, it is.
And is that statement true to the best of your knowledge and belief?
Yes, it is.
Do you have any clarifications to make in respect of that statement?
In this witness statement, I said that I hadn't seen the letter of instruction from Ms. Helliwell, which was correct at the time that I make that statement, but later on, at the back end of last week, I was provided with a number of other documents, and within there was the letter of instruction.
Thank you very much. I'm going to start today by asking you about your background. Your witness statement, WITN 002-10100, it doesn't need to be brought onto screen, but that's just for the purpose of the transcript. That will be published in due course.
Yes.
In terms of your background, it's set out in that statement. Most relevant for today is that in 2000 you were part of a company, you're a shareholder in the company called Best Practice Group PLC. Is that
yes,
right?
That's right.
Can you very briefly tell us what your role was in that company and what the company did?
Yes. We set up that company in 2000 because we'd noticed that technology within companies was accelerating rapidly. And whereas before technology was just an aid to businesses, technology was now being talked about in terms of business transformation, so requiring fundamental changes to businesses whilst technology was brought in. And we spotted that there was a number of what we at the time called misaligned expectations. The suppliers would think they was delivering one thing, the customer would think they were going to receive something different. So Best Practice Group was set up to help the parties come together throughout the contracting process to understand what would be delivered and what the parties' relative roles and responsibilities would be. And it was as a result of that that we started to be instructed by parties that had frustrated implementations to try and avoid disputes, and that built up our contact with law firms.
And was one of the roles that you had at that time acting as an expert witness?
Yes, it was.
And it was in that role that you acted in a case that we're going to be coming to, which is the Cleveleys case, or that we refer to as the Cleveleys case.
Yes.
You then moved in 2009 to IT Group UK, is that correct?
That's right, yes. And IT Group was looking purely at the distressed end of computing. So it was looking at things like failure mode analysis to find out why projects had gone wrong, whether they could be brought back on track or not, or whether we could provide expert witness evidence throughout the dispute resolution process if the contract needed to come to an end. So we help people like insurers, were instructed by law firms, often instructed by technology companies to advise how to get projects back on track, or purchasers of technologies to find out what they should change within their own organisation to make the technology project work better for them.
And it was while you were at IT Group UK that you acted in the Bates and Others litigation as also an expert witness.
That's right, from about 2016.
and that's something that we'll be looking at in more depth in phase 5 of this inquiry.
Yes.
You're now a partner in Evolution Project Consulting, is that
Yes.
correct? Is that broadly the same or different to those two previous?
No, it's broadly the same. The companies that I've worked for have gone through various mergers and acquisitions over the years, and Evolution Project Consulting is now just back to me on my own, rather than part of a larger organisation. But doing broadly the same thing, helping people with technology disputes.
And do you continue to act as an expert witness?
I do, yes. The company has only been operating on its own for a couple of months, so I don't yet have any instructions, but that is a desire.
When did you first become an expert witness?
I believe it will have been probably the turn of 2000, something like that, when we started Best Practice Group.
What did you understand, and perhaps what do you understand now, to be the role of an expert witness, in summary?
Well, the overriding obligation is to assist the court and to ensure that you take an independent viewpoint and that you consider all evidence very carefully. You don't fail to report any evidence that you have seen, and that you search out all the evidence that might be available. And it's really the independence side of it that was the very, very early teachings that I got from all of the material that I took from the Institute of Experts and all the different various parties that were involved in expert witness training in those early days, and still today.
And was it broadly the same in the early 2000s as it is today in terms of your duties as an expert?
Yes, I believe so. I think the majority of the changes were in the late 1990s, and CPR 35, I believe, was updated certainly before 2000 to ensure that experts were shown to be more independent, and in fact were more independent. And there was the Declaration of Independence that has to be signed now on all expert reports.
In the Cleveleys case, you were a joint expert.
Yes.
In the Bates litigation, you were an expert for one particular party.
Yes.
Can you tell us the difference between those two situations?
I mean, your obligations are still exactly the same. Your obligation is to assist the court, and you have to remain independent, whether you are instructed by two parties or whether you're instructed by one party, such as that was in the Bates litigation. So your opinions don't change. The way you go about the process, the analysis doesn't change. You have to take as much care and diligence, irrespective of which process is followed. The only difference really is that the two parties in a joint litigation, in a joint instruction, come together to generally agree what your instruction should be, and you accept that as a joint instruction. And then when you submit your report, you generally invite questions from both parties, and then you would generally respond to those questions. That's typically the process and the difference when it's a joint instruction.
Thank you. I'm going to move on to now talk about the Cleveleys case. You're the first witness in this inquiry who's going to be addressing questions on the Cleveleys case. So I'm going to take you through some very basic facts to begin with, just to set the scene.
Yes.
Can we look at poll 00118-218, please? And it's page 3 of the trial bundle. You'll see here that the claim was served, if we scroll down a little bit, on the 26th of April 2001, and it began life, if we look at the top, in the Croydon Crown County Court. And the value of the claim in the bottom right-hand corner is approximately £11,000. Is that your recollection?
Yes.
Yes. Can we look at page 5, please? So if we scroll on a couple of pages, there is the particulars of claim. The defendant is a lady called Mrs. Julie Wolstenholme. If we look at paragraph 2, she was the sub-postmistress at Cleveleys branch, and her contract had been terminated. The post office were suing her for return of certain equipment. And if we scroll over to the next page and keep on scrolling that to the end of the particulars of claim we have there, that's signed by a statement of truth by James Cruz or Jim Cruz, who will in due course become familiar with. And there's also the name Catherine Churchard of legal Consignia Legal Services. This is a document I think that you were provided with when you prepared your expert report.
Yes.
Thank you. If we turn over the page to the defence and counterclaim, and paragraph 2 of the defence, so it's page 8 now. This is Mrs. Wolstenholme's defence, and at paragraph 2 we see there it says the defendant asserts that her employment was terminated unlawfully and she's made an application to the industrial tribunal. So her defence was that she had been unlawfully
Yes.
Terminated. And there is a counterclaim in her claim. If we keep on scrolling down to the next page, towards the bottom of page 7, there appears to be a counterclaim. A little bit further down. There we go. So it begins at the bottom of that page. And if we go over the next page to paragraph 14 of the defence and counterclaim. Thank you. Perhaps if we could blow up paragraph 14. This is where the issue of the computer system is raised. It says there, further or in the alternative, it was an implied term of the contract between the claimant and the defendant that the computer system provided by the claimant would be fit for purpose, and the claimant is in breach of this term in that the computer system provided was unfit for purpose, and the claimant failed to ensure that the system was working adequately.
Yes.
Thank you very much. And if we scroll down to the next page, Mrs. Wolstenholme was claiming damages. If we keep on scrolling down, damages for wrongful dismissal, damages for breach of the implied term to provide a computer system fit for purpose, and further damages, and it's signed there at the bottom of page 12. And the date of this document is the 6th of June 2001.
Yes.
Which may be of relevance because we're going to address issues of the provision of audit data, etc. So the date that the claim began and the date of the defence here is June 2001, when the issue of the computer system was first raised. If we scroll over the page, there's amended particulars of claim. These don't matter for present purposes, and we can continue scrolling to page 15, which is the end of the amended particulars. And at the bottom of that page, we see the name of Miss Helliwell, who we'll be hearing from later today, who is the signatory there.
Yes.
If we continue to scroll to page 17, this is still with the amended particulars of claim. We see there for the first time appearing in this bundle the name of Waitman Vizard's solicitors, who by that stage were on record acting for the Post Office. Can we please turn now to page 93 of this bundle? This is the Post Office's reply to Mrs. Wolstenholme's defence. By this time, we're in the Blackpool County Court, so it's been transferred.
Yes.
And if we scroll down, we'll see that that's the reply and the defence to the counterclaim. And it's page 95, paragraph 4. that we see there that the Post Office state it is denied that the said computer system was unfit for its purpose, and it is averred that the same worked adequately. Thank you. I'm going to take you to a few court orders just to set the scene and again to take you to a few relevant dates for your instruction. Can we turn to page 98, please? This is an order of the Blackpool County Court of the 16th of July 2001. And if we look at point B on the notice, it says there may be an issue as to expert evidence given the counterclaim.
Yes.
Can we go to the next page, which is another order, this time the 30th of August 2001. Order paragraph 2. At this stage, it says both parties have permission to rely upon one expert each in computer systems. And if we turn to page 103, thank you. That's an order of the 5th of August. It seems as though by that stage there was a stay until October of that year, possibly because employment tribunal proceedings were continuing during that period.
Right.
And if we turn over the page to 104, that's the 14th of February 2003, so by this stage matters had resumed. And if we look at paragraph 8 of that order, it is ordered by the Blackpool County Court that on it appearing to the court that expert evidence is needed on the issue of liability/causation, and that the evidence should be given in the form of a written report of a single expert instructed jointly by the parties in the field of computer technology. So this is the first mention of a single joint appointed expert. Can we please now turn to page 107. Thank you very much. So by the 17th of May 2003, we have Mrs. Wolstenholme writing to the Deputy District Judge, and it appears that she is complaining in this letter that Waitman Vizards hadn't yet appointed an expert, and also that she had requested call logs and they hadn't been provided. And if we go back a page to page 106, this is the subsequent order of the 5th of June 2003, where the district judge says that upon reading her letter and it appearing that the claimants have failed to give standard disclosure to the defendant and that the parties have failed to instruct a single joint expert, the matters listed for essentially a case management hearing.
Yes.
And then we turn to page 110. A case management hearing has ultimately taken place on the 7th of July of 2003, and there are certain orders made that are relevant to your instruction. And paragraph 1 says that the claimant do by 4 p.m. on the July the 21st serve on the defendant copies of the relevant computer logs from June 2000 until November 2000. And paragraph 4, it says there, it appearing to the court that archive material on the computer may have been destroyed, it is directed that claimant solicitors to make further inquiries and copy any correspondence to the defendant, and the parties are to make inquiries of expert as to whether an opinion can be given using the computer logs only.
Right, yes.
Can we now turn to poll 00118221, please? And it's page 47 of that bundle. This is part of the trial bundle, but there are relevant documents within that I'm going to take you to. This is page 47. We're now on the 3rd of September 2003. Thank you very much. And this is a letter to yourself at Best Practice Group. And It is from Waitman Vizards, and it says at the beginning, we refer to previous communications between this firm and Judith Boren and confirm that we're acting on behalf of the claimant, Post Office Limited, in connection with its claim against Julie Wolstenholme. Can you assist us? Who was Judith Boren?
Judith at this time was working in the capacity of as a general administrator within Best Practice Group.
Do you recall why you were selected at this stage?
Possibly proximity to the to the computer. I live in near Preston, Lancashire, so it's only relatively around the corner from Cleveleys, perhaps, but I really don't know.
And it appears as though there was a conversation before this letter discussing your instruction.
Yes, and I seem to think that it's a hazy recollection, but Judith will have come to me and explained that we've had a call, an inquiry, what types of things would we need. So it probably will have been Judith that went back to Susanne Helliwell and said, I've spoken to Jason, and these are the things that he would need in order to opine on this.
Thank you. Can we go to the bottom of this page? Can I just check? You mentioned Susanne Helliwell there. Was she your only contact at Waitman Vizards? Was there anybody else that you had contact with, or did you speak to the post office?
No, I certainly didn't speak to anyone directly at the post office, or I don't believe I did. I think it was only Susanne Helliwell that I dealt with at Waitman's.
Thank you. Can we have a look at the bottom paragraph of this page? And it explains the background. So various matters are raised by Mrs. Wolstenholme in the proceedings regarding the inadequacy of the Horizon computer system. And in this regard, on the 10th of February 2003, it was ordered that evidence should be given in the form of a written report of a single expert instructed jointly by the parties in the field of computer technology.
Yes.
Can we scroll down the page over to the next page? Just looking at this letter here, can you summarize briefly for us what you were asked to do?
To produce an opinion on whether essentially the use of the help desk by the Cleveleys post office was reasonable use, whether the calls that were being placed to the help desk by the sub-postmaster were placed appropriately. And I was given somewhere between 80 or 90 call logs, really without very much context. And I was asked to go through those and effectively categorize them as calls requesting general help. So, for example, could you tell me how I do this? So that might suggest a lack of training or a lack of understanding, or whether they were calls relating to a defect, generically a defect, could be with hardware, software interfaces in the operation of the system, and therefore the sub-postmaster called the help desk seeking guidance and resolution about that defect. So that's the process that I went through.
As we saw from those previous court orders, it seems as though by that stage there wasn't the audit data available to actually look at the underlying transaction data. Is that correct?
Yes, but I think that in itself is quite surprising, and you know I did note that there was talk about data being kept on the machine for so many days. I think it was 30 days. And then data being removed after 18 months. From my knowledge since this matter, I don't believe that would have been correct at the time. I don't believe that archived data would have been removed after 18 months. So perhaps there was other data that was available. There were certainly things like KELs and things like that was available at the time that would have assisted me to come up with my opinion, but none of those were provided either.
When you say you think that the audit data would have been longer than 18 months, is that because you know subsequently that later data had been held for
Yes.
longer? So that it may have been that there was a change in the procedure and how long they held
It's
data.
possible that there was a change, and that statement was correct at the time. Certainly later on, data was kept for a lot longer than that.
The letter that's on our screens right now, is that what you understood to be a letter of instruction?
Yes.
Thank you. Can we go over the page now to page 49 of the bundle? It's another letter. This is a letter from yourself to Miss Helliwell of the 19th of September 2003. Looking at this document, can you tell us what your response to that letter of instruction was?
Yes. So I said it's not clear to me what you're asking me to do. You've simply provided me with 70 or 80 telephone call logs. And in order to opine whether the system was operating normally, that what I would need to do, I'd need to do a comparison of the Cleveleys sub-postmaster Horizon system with other terminals in other branches to see if I could see whether there was a difference with either the operation, the way Ms. Wilson operated the system, or whether there was something specific about the technology within Cleveleys, or whether this was stereotypical of all the Horizon systems.
And it seems as though what you're asking for there is a further set of logs
Yes.
from other branches.
Yes.
You're not asking there for example, statistics, but you're
No.
asking for the actual underlying logs from other branches.
Yes, and I actually say that I believe a further set of support logs would be required.
And if we turn over the page, we have the response from Wakeman Vizards, 17th of November 2003. And it's the bottom of that first page that I'd like to look at. It says there, as you're aware, our client has unfortunately been unable to obtain a set of comparable call logs, and it has therefore been agreed between the parties that copies of the pleadings, witness statements, and relevant documents in the proceedings will be provided to you to assess with a view to confirming whether you would be able to provide a report which would be of value to the court, and if so, detailing the matters upon which you would be able to report.
Mm-hmm.
So you're being told in that letter that there isn't a comparable set of call logs. Was your understanding from reading that there wasn't a set of call logs, that there was an issue with finding comparable cases, or what the issue was there?
I believe that because I'd set out various criteria, similar number of staff, similar size, that they were unable to find either a similar sized or similar turnover post office. I now know that statement that's made there can't really be correct at the time, because as a better understanding of the post office estate there would have been many sites that could have been used as comparators, and because I now understand that these are peak logs. Well, there was many thousands of peak documentation that could have been used, and the support logs that could have been used to pull together that comparable information.
Thank you. We dealt with this in phase 2. Mm-hmm. At that time, there may have been pinnacles as well as peaks.
Yes,
or at some stage, it switched
That's right.
over.
Yeah.
I'm going to turn to your report in a moment, but before we look at your report, I just want to bring up the statement that had been submitted in those proceedings by Elaine Tagg, who was the retail manager of the retail network manager at the post office. That's POL 00118219. This again was in the trial bundle, so this was in a bundle that you would have seen at the time.
Yes.
And I think, in fact, we'll see in your report that you refer specifically to the witness statement of Ms. Tagg. That's at page 5 of this bundle. So this is a statement of the 16th of October 2003, and it explains there that Ms. Tagg was employed by Post Office. Her title was previously Retail Network Manager, and at some point it was changed to Retail Line Manager. Mm-hmm. Can we go, please, to page 7? And I'm going to just look at 2 paragraphs there because you refer specifically in your report to the second of these 2 paragraphs. It's paragraph 11 and 12, so the bottom of page 7, please. So paragraph 11 sets out the difference between the Horizon System Help Desk and the NBSC.
Okay, yes.
And then if we scroll down to paragraph 12, there's the fire alarm. We'll just take a short
Attention,
break.
please. Attention, please. This is the test of the fire and voice alarm system. There is no need to take any action.
Okay, I think we can continue. Could we zoom in to paragraph 12, please? I'm just going to read out that paragraph. It says, Mrs. Walthenstone persisted in telephoning the Horizon System Help Desk in relation to any problems which she had with the system, and generally, these problems related to the use and general operation of the system and were not technical problems relating to the system. Mm-hmm. Copies of the call logs for the period 10th of January 2000 to the 30th of November 2000, together with a brief analysis of the calls to the Horizon System Help Desk, which I prepared following Mrs. Wolstenholme's suspension, are at, and she gives the reference. Whilst there were some problems at other branches, they were not insurmountable and were often due to the system crashing or were general teething problems. Mm-hmm. This is a particular paragraph that you, in due course, pick up. I'm just going to take you to a few more extracts from this witness statement to provide a bit more context. Can we look at paragraph 15? That's over the page on page 9. And it's the second half of paragraph 15. She says, in the first 6 weeks of Mrs. Wolstenholme's appointment and prior to the installation of the Horizon equipment, the office had an average balancing record. Following the installation of the Horizon computer system, a period of adjustment time was allowed, and in any event, the shortages at Miss Wolstenholme's post office were not excessive up to June 2000 for an office of that size. The next paragraph, she says that on the 1st of June, there was an audit, or the results of an audit, and it can be seen that the report states that there were good controls in relation to the Horizon system. And then it's paragraph 17 where she says on the 21st of June 2000, she wrote to Mrs. Wolstenholme stating that it was now some 10 weeks since the Horizon system was deemed to be fully operational, and stating that there was currently a loss being held in her account in the sum of £2,497.94, and requesting that arrangements were made to repay the loss. Mrs. Wolstenholme responded by letter dated the 9th of July 2000, blaming the shortages on the problems which she claimed to be having with the Horizon system. Mm-hmm. If we go over the page, it says there, the post office was not experiencing any problems of this nature with the other sub-post offices. And as I've stated above, whilst there were some problems at other offices, they were mainly teething problems or involved the system crashing and were not ongoing to the extent of the problems which Mrs. Wolstenholme was experiencing. I was very much of the view, as it is evidenced by the call logs, that the problems which she was experiencing were largely due to the misuse and operation of the system, and apart from the times when the system crashed, were not usually the fault of the system. If we scroll down, we'll go over to the next page, page 11, paragraph 22. I'm going to, again, read that paragraph. It says, on the 1st of November 2000, I received a call from Mrs. Wolstenholme, during which she informed me that the Horizon system had crashed and that she was unable to roll 2 stock units, namely those of herself and Mr. Harrison, in the next cash account period. Just pausing there, this is actually a log that we're going to come to in due course. On the 2nd of November 2000, I attended Cleveleys sub-post office and met with Mrs. Wolstenholme. My colleague, Carol Hargreaves, another retail line manager, was also in attendance. We found the system to be operational, but accepted that there had been some problems following the upgrade, none of which would have prevented rollover. Mrs. Wolstenholme was reluctant to open the office as she felt that the Horizon system was malfunctioning. Mr. Harrison indicated that he may turn off the system as he had no faith in it. I warned him at the time that Mrs. Wolstenholme would be in breach of contract to do this and would be suspended. Carol and I checked the cash and stock, which was correct, and the office opened at 2 p.m. During my visit, I discussed with Mrs. Wolstenholme the position regarding the losses on her account. If we go to page 13, this is the penultimate paragraph that I'm going to be taking you to this morning. It's paragraph 26, just the top of paragraph 26. It says, on the 30th of November 2000, I received a call from the post office helpline to say that Cleveleys sub-post office had not rolled the office and that again, only Mrs. Wolstenholme and Mr. Harrison's stock had been affected. I was also informed that the sub-postmaster had reported a large shortage and was refusing to roll the office over until the problems were sorted out. I telephoned the office and told Mr. Harrison to open the office with the 8 stocks, which had been rolled correctly. He stated that the office was already open, but that they were working manually and would not be using the Horizon system until it had been sorted out. I'd now just like to look at the very final paragraph of this witness statement. It's page 19. Ms. Tagg ends that statement by saying approximately 18,000 post offices are using the Horizon system, which is fully backed by the Federation of Sub-Postmasters. I am of the view that the problems encountered by Mrs. Wolstenholme stemmed from the misuse and operation of the system, and save for the early teething problems in February/March 2000, were not technical problems relating to the Horizon system itself. On the occasions when I and other employees at the post office used the Horizon system at Cleveleys post office, we experienced no problems whatsoever. The post office had grounds to terminate Mrs. Wolstenholme's contract, and the contract was properly terminated. And we see at the bottom of that statement a statement of truth. Do you recall reading this at the time?
I do, yes.
I'm now going to turn to your report. That can be found at WITN 002-10101. And this is your covering letter to Ms. Helliwell, 21st of January 2004. If we turn over the page, this is your opinion. Now, on the second paragraph there, you set out your initial opinion prior to examination. Can you briefly summarise your initial opinion for us?
So what I set out here is that of the calls that I've examined, the call logs that was provided, that 63 of those calls are without doubt system failures. So relating to either hardware, software, or interfaces. And only 13 of the calls that I looked at could or should be considered as Mrs. Wolstenholme requesting help or guidance.
Sorry to pause you there, but I think that's your substantive opinion.
Yes.
In the second paragraph, if we could just zoom into that, you gave an initial opinion. I think you're repeating the initial opinion there.
Yes. No. What I was saying there is it would be difficult of me to give an opinion without a comparative across the estate. But when I was told that wasn't available, I was told that I would just have to give an opinion based on the call logs that I've seen for the Cleveleys one.
Thank you. And then if we go about halfway down that page, it begins the statement from Ms. Tagg. And if we could highlight perhaps from there down to and including the penultimate paragraph. So yes, to the bottom there from the word this, if we could highlight that section.
Yes.
You make findings based on Ms. Tagg's statement. Can you please tell us what those findings were up to the
Yes.
penultimate paragraph?
So I say that, in my opinion, what Miss Tagg states it is not a true representation of the evidence that I've seen from looking at the calls, the 90 or so calls. And as I stated a minute ago, 63 of those calls are system failures, and only 13 are Miss Wolstenholme calling the wrong support help desk. And in Miss Tagg's statement, she suggests that the vast majority are asking for help, and that there's practically no reports of system problems. And then I go on to say that the system issues that we see, screen lock, freezes, and blue screen errors, can't possibly be of Miss Wolstenholme's making, but are due to the faulty computer system. And I specifically highlight a call there, and I make reference to the constant rebooting that was requested of her.
And in fact, if we look at the final paragraph on that page, you address the advice from the Post Office to reboot the system. Can you tell us what you say in that final paragraph, or summarise that final paragraph for us?
Yes, from looking at the detail in the call logs, there appeared to be a pattern emerging where Miss Wolstenholme was told to reboot, just simply reboot the terminal. And I made the observation that whilst rebooting might get you back up and running, it essentially masks what the underlying problem might be. There needs to be analysis of things like crash dumps. You know, why did the system freeze? What did go wrong? But I couldn't see within the call logs that analysis was really going on. It was more just get the machine back up and running. I mean, that's not to say that people weren't changing things in the background, but you couldn't necessarily see that from the logs. And in fact, from the knowledge in Bakes, we know that there was a huge amount of changes that was going on in the background and being pushed out. So it might well be that, you know, a reboot and then a couple more days, something then might change with the Horizon terminal.
Can we go over to the next page, which is it a continuation of the opinion, or it has the word opinion at the top? Are you able to assist us with whether this is the core of your opinion or something different to what we've just seen?
Yeah, it's a very curious note, this, really, and it's not in the format that I would typically put together expert witness notes with. And it was my consideration at the time is that this was a report that would go in that would then prompt additional information being provided, and that ultimately might turn into a better formatted expert report with various sections. But because there was almost very little to work with, it's formatted in this curious way. It's more like an observation, a canter through the various highlights that we see in the call logs.
Thank you. Beginning with what's at the top, down to but not including the paragraph that begins from the 31st of October, are you able to summarise the types of faults that you observed and your findings in that respect?
Yes. So when a screen freezes, you can be pressing the keys and nothing's happening. That has to be a system fault. The user can't cause that, and we certainly saw those types of problems. We had blue screens where the operating system crashes, You may well see it on your home PC. You often call it the blue screen of death. You lose all your work, and it's just a blue screen. That can't be anything that the user can cause. It's typically a hardware fault. And there was a number of those that was going on. There was also the need to exchange hardware. Hardware was switched out by Post Office or Fujitsu, suggesting that they suspected ongoing hardware problems, although it would seem that there was no real improvement that was made. I also point out that there was a reduction in the calls at the end of June 2000, and I'm not sure if we managed to identify what that might be.
I think you say in the report that it could be due to the faults reducing in frequency, but it could also be that Mrs. Wolstenholme tired of...
That's right. Yes. One thing that happens with users, and this is from my direct experience of managing help desks, is if the users are constantly told to reboot, effectively they'll stop ringing the help desk, because if all you're told is just to reboot, well, you might as well reboot yourself. You don't have to waste your time on the phone knowing that someone's going to tell you to reboot. So you do see that apathy, I think it might be, that you just simply reboot yourself and don't log the call.
So a reduction in calls could be caused by a number of things. It could be caused by the system being fixed.
That's
also
right.
It could be
Yes.
caused by apathy, as you've...
Yes. Mm-hmm.
If we look at the bottom two paragraphs of this page, can you please summarise those paragraphs for us?
Yes. So we start to see within the call logs discrepancies being discussed. Whether the word itself, discrepancies, are mentioned, or whether it's an imbalance, or something failed to post, or something like that. And there's a reference to all sorts of figures showing minuses where they should be pluses. So that appears to be something within the Horizon system as either changed, so a different version has been pushed out by Fujitsu that's tried to fix something and has perhaps broken something else, or alternatively, a new type of working has been experienced at Cleveleys. They're doing something in a different way, and that's exposed defects within the Horizon system.
And the final paragraph?
So in one of the calls, it says that the PM was advised that this was an issue since an upgrade has taken place. So consistent with what I've said before, a new version of Horizon has been released, was pushed out to the terminals, and although the postmaster wouldn't necessarily know that they was using a new version, behind the scenes it would be a new version, and it would seem that this problem has been seen across the estate by Fujitsu since they've moved out an upgrade.
Thank you. I'll take you to that particular call log shortly. Mm-hmm. Can we just turn over the page, please, to the summary of your opinion? You have three conclusions there. Mm-hmm. Can you please take us through briefly each one of those conclusions?
Yes. Okay. So I say that the technology installed at Cleveleys was clearly defective in elements of its hardware, software, or interfaces, and that the majority of the errors in the fault logs could not be the making of Miss Wolstenholme. The next statement I made is that Post Office is more focused on simply closing calls rather than trying to get to the bottom of what the issues might be. And the instruction to reboot would allow the business to get back up and running again, but it could potentially mask the efforts, certainly from the post office to postmaster, to understand what's going on. And then I also point out that whilst there was a reduction in calls between July and October, it might be user disillusionment with the help desk or comparative system stability. But then I do point out that from late October, the reoccurrences of the faults, which have been the subject of the earlier log calls, seem to resurface after, in quotes, an upgrade to the counters, which seems to have occurred around the 23rd of November 2000.
Thank you. I'm now going to take you, just by way of an example, to one of those logs that you analysed. Can we look at poll 001182252, please? And it's page 24 of that particular document. This does feature in the trial bundle, but this is just a clearer version of the same document.
Yes.
We see there, this is an issue that was opened on the 1st of November 2000, so that was the date that I took you to in Ms. Tagg's statement. And we see there the caller is Julie Wolstenholme. Are you able to interpret the particular problem, very briefly for us?
I mean, I think the simple answer is not. I wouldn't be an expert in the actual process that was going on. But there certainly appears to be an issue with the adjustment of stock figures, and that they appear to be showing in the different units. So there's some sort of imbalance going on as a result of a fault.
And if we scroll down to the fourth entry, this is something you've already referred to.
Yes.
It says there, PM advised that this is an intermittent problem occurring since the counters were upgraded on the 23rd of October. Thank you. And if we go over the page to the second entry of that, it says, still awaiting a reply, getting very upset, waiting to balance and get to family, etc. This is a call on Wednesday, so I think Wednesday may have been balancing day, and this was 7:08 p.m., 7 in the evening, and it seems to record a message from Mrs. Wolstenholme.
Yes,
getting upset.
and it's part of this is to do with the entry of, or the remming in of the smart cards. So entering them into stock and registering the value of those cards within the system, and that it would appear that they didn't register correctly, or they registered on one terminal but not the other terminal, or with a different value.
And we see below that it says R&M, so Regional Manager Elaine Tagg, that's the author of the witness statement.
Yes.
Called, re the call. She's on her way to the office and wants updating on the situation. Spoke to Ref Kath on third line, who advised she'll check who is working on the call and get them to ring the office ASAP. Message relayed back to the regional manager. Regional manager not very happy with the response. If we go down 1, 2, 3, 4 further entries, it says PM, postmistress, chasing call. Contacted EDSC, who advised are looking at this now, relayed back to PM, who advised has managed to roll 7 stock units, but 3 have not. Advised PM needs to contact MBSC and let them know of the situation, as they will probably not be able to do cash account. The one below says MM calling. They have called a few times now. I think that may be regional manager calling. They've called a few times now, expecting a call back with info, and no one has called them. The office is closed, but they're waiting for a call. The next substantive entry says, contacted the regional manager for this office, as she has now made a complaint regarding the issue. Elaine advised that all SUs have now been rolled over, and they're now checking them to see if the final balance is showing to be correct. one of the SUs had something added to it whilst rolling over. Elaine was very annoyed that no one from third line had called her back, as she had been promised a number of callbacks, apologised for not receiving any callbacks, and advised that I would escalate the facts that the agents she has spoken to have promised callbacks within the hour, as they should not be making promises like these, advised that third line are very busy with their investigations and sometimes do not have time to call back. They may call back sometimes if they require additional information, etc. Advised that I would monitor the call, and if any updates occurred, I would notify them. The entry below says that there is a KEL, and it says the KEL explains that this is currently being investigated by the development. I've not spoken to the customer. Do you now know what a KEL is, and did you at the time?
I don't believe at the time I knew what a KEL would be. It would be my expectation that I should have been provided with the KELs that matched the call logs, because that would have helped my opinion vastly.
There's an entry of Monday the 6th of November, which says contacted PM on the 6th of November. And if we look at the end of that entry, it says not made any declarations, 4,000 short in balance, that must be balance.
Balance, that week.
Yeah. And then the entry below says call E was reassigned from the Horizon Help Desk to group SMC1, reassigned for development, as this is a known problem with KEL and await solution.
Yes, so that's the software needs to be changed to fix this problem.
We read earlier, that can be taken down, thank you. We read earlier the statement from Elaine Tagg of the Post Office that stated to the effect that Mrs. Wollstonholmes' calls to the help desk were not technical problems. Was this a technical problem?
Yes.
We also read in the statement of Mrs. Wollstonholme, Mrs. Tagg, that suggested that post offices weren't experiencing this kind of problem, or the kinds of problems that she described. Seeing as we know that there was a KEL, a known error log for this particular issue, was that a fair statement?
No, it was an incorrect statement. I mean, certainly there were a large number of problems at Cleveleys, and with the information that I finally got from Post Office, whilst it wasn't comparative logs, it was giving me high-level information about the types of problems in another, I think it was 6 post offices. They were suffering large numbers of problems with hardware and software of interfaces in the same way that Cleveleys was. And I asked for that to be representative of the estate. So that suggests that the whole estate was suffering similar types of problems as what was being experienced at Cleveleys at that time.
Seeing Mrs. Tagg's name as the regional manager and the contact with the help desk in this particular instance, do you have any views on whether her statement was fair and accurate?
No, it wasn't fair or accurate, because she clearly would have had knowledge of that particular call, and was keeping abreast of what was going on, so was fully aware that there was technical problems.
Thank you. I'm going to move on now to some discussion within Fujitsu about your report, and also official responses to your report. Can we please look at WITN 04600304? These are comments made by Steve Parker to Jan Holmes within Fujitsu. So it's not an email that you would have seen at the time. It's dated the 17th of February 2004, and we'll come on and see that there was an official response on the 20th of February.
Yes.
So shortly before the official response. And they seem to be comments on your report. I'll take them one by one. If we look at the first, there's a comment on the passage which says that the technology is clearly defective.
Yes.
And he says there, any technology that runs 24 hours a day will have hardware defects that require fixing. This is normal business. Do you have a view on that at all?
So it would be fair to say that there is a risk that exists that with any technology that runs 24 hours a day, it will at some point in time suffer a hardware defect that will require fixing. But it will require that qualification that they call it the mean time between failure. So how much time would you expect before the next failure exists? We were seeing failures in Cleveleys almost on a daily or a weekly basis. So that is an unreasonable mean time between failure. So there is a real danger with that statement that's made there, that the non-technical user reading that might take that to be that I'm incorrect in what I'm saying, whereas I think what is being said is actually he agrees with what I'm saying, but I think it's very, very clumsily worded.
If we look at the second point, he says, he comments on your point about the help desk being focused on closing calls, and he says, true, but this focus is also about getting the PM working again in the fastest possible time to ensure that the PM's business is not interrupted. It's a trade-off between time taken to diagnose and impact to PM's business. Do you have a view on that at all?
Well, and again, it is true. Whenever you're going to decide to reboot and get up and running, and we will see this in our own businesses, that there is a trade-off. Do I spend the time on the telephone reporting all the issues to then just reboot, or do I just reboot myself? At least I'll be up and running. I'll be operational. The business continue to be trade. The difference here is the process of rebooting and not analysing the information that's led to it could well mean that you have accounts that are incorrect as a result of that system flaw, and ultimately that imbalance, that discrepancy, may well be used in evidence against you in later action. So I don't think it's fair on the sub-postmasters for Fujitsu to be using the fastest possible, or Post Office to be using the fastest possible approach to getting the Horizon terminals back up and running then. Because essentially it's only Fujitsu and the Post Office that benefit from that reboot and get up and running. The sub-postmasters are potentially massively disadvantaged by that.
The third point comments on your view that there were worrying discrepancies. He says, must be the major issue. Counter systems caused discrepancies. Answer has to be no way. And he makes 3 points. The first is almost all accounting errors in computer systems are caused by user error, GIGO principle. Is that garbage in, garbage out principle, or?
I think it is. I mean, you know, it really is quite a delusional view, though. I mean, why should it be the case that accounting errors are caused by user error? Anyone in technology will know that it's typically bugs within the code that will lead to the types of errors that we see here. You've always got to examine what the user was doing and whether it was being used appropriately. But if these systems are designed to be quite robust, it's typically a software defect that will lead to an imbalance.
B, systems are in place, MBSC, suspend account entries, etc., like any other computer system, to ensure that such discrepancies can be resolved. Do you have a view on that?
It is true that over time, a number of additional systems and processes were set up by Post Office to deal with the inadequacies of Horizon in the early days. And there was a number of other checks and balances and teams of people that were fixing transactions. So it's true to say that whether they were at this point in time or whether they developed later over time, systems are in place. But there was the huge potential for flaws, and they were very heavily human-based systems that were put in place, and that some of them were mechanized later.
So when you say human-based, do you mean workarounds and things like that rather than...
Yeah, workarounds and people putting something into an Excel spreadsheet and seeing if it added up and making corrections and, various human workarounds.
There's reference to the suspense account being a system in place. Are you aware of the suspense account being removed at a point in time?
Yes, I was. I don't recall at the moment when the suspense account was moved. But yes, the suspense account would allow a place for transactions to be essentially parked until it's worked out later what has gone wrong, whether it was a misposting or whether it was a defect, and then it could be taken out of the suspense account and reposted somewhere else. And then that was removed later.
If we look at C, he says, yes, software errors can make such mistakes. However, the systems in place ensure that such errors are picked up and resolved. If this problem is caused by a software error, the same error would exist on all Horizon sites. 17,000 postmasters are not complaining of misbalancing and discrepancies.
No, that's incorrect. What you see with defects in software is that they may only trigger with a very specific series of either key presses or series of transactions or certain events going on within the estate. Because when developers test software, they generally test what's called the happy path. So if everything goes well with the transaction, you'll get the successful result at the end. So it's only if something differs within that, or if certain types of transactions that have done, or certain transactions are done in certain sequences. So what goes on at a particular post office that exposes a defect may only be seen in a handful of other other post offices. Because of the nature of it, and certainly in some of the defects that we looked at as part of the GLO, you will see in the bug table at the back, some of the defects only hit 20 or 30 or 50 different post offices at various points in time. So that's an incorrect statement.
Thank you very much. Sir, we're about halfway through Mr. Coyne's evidence. Because of the timetable today, I think it may be sensible to actually take our first break of the day now.
Yep. That's fine. Yep.
So if we could come back at 5 to 11.
5 to 11, that's fine. Okay, see you then.
Thank you very much. Thank you, sir. I'm going to try and perform some computer wizardry of my own and bring two documents on side by side. One is FUJ 00121512, and the second is FUJ 00121535. Thank you very much. On the left-hand side of our screen, we have the Fujitsu response to your expert report. and on the right-hand side, we have your response to their response.
Yes.
So the left-hand side is dated the 20th of February 2004, and your response is a week later, 27th of February 2004.
Yes.
And I'm going to take you through one by one each of their comments on your report. So if the left-hand document, if we could go over to the next page, please. Thank you. So they address first the Horizon System Help Desk. Can you assist us with what your understanding is of what Fujitsu were saying about your comments on the Horizon Help Desk?
So Fujitsu are explaining that there is a what they call a strict contractual service level agreement covering aspects such as pick-up time, time to fix, time to close, and that they operate to that criteria because that's the commercial contract that they have with the post office. So it could well be the case that it is better for Fujitsu to close a call by rebooting a computer than it is to spend a lot of time investigating it, because that might put them in breach of the service level agreement. I don't know. I haven't seen that service level agreement, and that's why I've said it's a matter for the post office and Fujitsu, because it's their commercial agreement rather than me to comment on that.
And the final part of the entry on the left-hand side says, whilst the primary objective of the HSH is to return the outlet to normal operation as soon as possible, and rebooting the counter often means that objective, meets that objective, this does not mean that the problem is closed at that point in time, as a detailed scrutiny of overall problem management processes will reveal.
Well, that may well be the case, and in my report I requested other information with regard to these calls, and I was told that there was no information available. So if there's other material available that references the calls that were made by the Cleveleys Post Office, then that should have been provided to me, so I could have opined on that.
And as an example of that, the known error log.
Yes.
In respect of this particular entry, knowing what you know now, the experience that you've gained over the years, your involvement in the group litigation, etc., do you have any observations now on that particular issue?
Sorry, when you say that particular issue...
So the Horizon System Help Desk point from your original report, do you still stand by it? Do you have any other thoughts that have developed over time in relation to that?
Well, I've got a far better understanding of how the process operates, how the calls are placed, the different tiers of support, and the documents that are created throughout that process. But I don't believe it operates significantly different when I was looking at it in 2016 to 2018 than what it operated then. You know, the desire to reboot and get operational appeared to be consistent then with what it now with what it was then, and the fixing of faults and effectively pushing those fault fixes out in the background was also the same. And I think in my second report to the GLO, I listed the number of release notes suggesting that something had been changed and pushed out, and it was in the thousands. So the system constantly evolves, and for that reason, the reboot. It's conceivable that the rebooting might not fix the problem, but if something is changed in the background and then you're told to reboot, then that might actually lead to an improvement.
If we scroll down on the left-hand side, Fujitsu then address the transaction handling on reboot. Mm-hmm. Are you able to assist us with your understanding of what Fujitsu's position on that was. And it may,
Yes,
we
yes.
can scroll down the page as well onto the next page on the left-hand side. And because they say, simply put, the design of the system precludes the possibility of a session stack being partially or doubly committed, and thus accounting errors cannot be introduced through a system crash or forced reboot.
Yes, and that always has been the position that's been advanced, and that was the position that was advanced in the GLO later, and that essentially by rebooting, there couldn't possibly be any inconsistencies within the counter transactions. Although as the number of different types of transactions occurred, and certainly other sort of off-counter transactions, Camelot and things like that, and credit and debit card transactions, as it started to grow, as we opined in the GLO, there were certainly bugs, errors, and defects that related to that to that process, and it was shown that discrepancies did occur as a result of that.
So is that statement at the bottom of the left-hand side, in your view, incorrect?
Well, the design, if carried out effectively, should have precluded the possibility. So from a design perspective, but bugs, errors, and defects in systems aren't by design. They creep in as a result of development or a lack of testing, or just circumstances that haven't been considered, that need dealing with when they arise. So because the reference is to design, then it might not be an incorrect statement, but it doesn't set the context correctly.
And if we look on the right-hand side, can you summarise what your response was at the time on that particular issue?
Mm-hmm. That I would, just by Fujitsu simply stating that is their position, I could not accept that as altering my position. And whilst I said whilst it assists my understanding, it would not be proper of me to alter my opinion based on an explanation. But if you can present supportive evidence to me, but I was told that had been destroyed, I'm more than happy to consider that evidence.
Thank you. Moving down on the left-hand side to reasonableness of calls to the help desk.
Yes.
What is your understanding of what Fujitsu were saying in relation to this particular point?
So Fujitsu had looked at some call logs, and these should have been the call logs that should have been disclosed to me, but they said that they couldn't be disclosed to me. But then they'd found they gave it a particular term for these call, it was unregulated data or something like that they then looked at. They'd then done some analysis on those calls and had presented in overview their view from looking at those calls. And they were setting out in that table the detail. But if you look at that detail, you've actually got, for example, H is hardware. So if you look down the H column, you can see that Headingley 5, Dungannon 2. So pretty much in that representative sample, lots of people were suffering from hardware issues. A number were suffering from implementation issues. Sorry, can you just show me the legend a bit further down?
So if we scroll down slightly, and it actually goes over the page as well.
Yeah. S is software. I mean, you know, there's some very big numbers there in software, and so all of the post offices that are listed on the left have all been suffering software problems. So these aren't user problems, because user problems will be under A, advice and guidance.
And are you, in interpreting that particular table, also reliant upon what call type had been attributed to that call by the help desk itself or by whoever is making the log in the first place?
Yes. On the left-hand side, this isn't my data. This is Fujitsu's data, and they have put the numbers in the respective boxes. So it's Fujitsu that have decided, for example, that Headingley has suffered 27 software calls in a particular period. And I say I don't know what that period actually is.
I think you said earlier that you hadn't been provided with the underlying logs and had asked. Just to clarify, you didn't have a conversation with Fujitsu about this. This was with Waitman Vizards or with somebody else?
No, that's right. That's correct. I didn't have a conversation with Fujitsu about that. But I believe I say in my response, yes, I do. So under reasonableness of calls, second paragraph starts with "now it seems." So what I say there, now it seems that your client has located data that it believes enables comparison, although the raw data has not been made available to me.
And I think if we scroll down on that page as well, I think there's another paragraph under the reasonableness of calls.
Mm-hmm. At the top of there, I say, although I stress that no raw data has been provided, so I am disadvantaged. Is it your client's intention to rely upon the data sample referred to in this letter? So am I to take that table as evidence that I should be considering, or am I going to get the raw underlying data?
And if we could scroll down on that left-hand side, what is it that Fujitsu were saying that analysis shows?
So Fujitsu was suggesting that Cleveleys is no better or worse broadly than the rest of the estate, which I thought was quite a bizarre position to take, and I think I made a comment on this, because it appears that the whole estate was suffering huge numbers of problems. So by just saying they're all as bad as Cleveleys, I didn't know why that was helping anything. But then what they say is it is worth noting that Fujitsu Services is not aware of similar complaints or claims being made from the other outlets on the list. But I know full well that there was a number of complaints and claims being made broadly across the estate. That's not to say that it was those particular post offices on the list there. So I didn't know whether that list had perhaps been cherry-picked because there'd been no complaints by them or not. But I know across the estate that there was large numbers of problems.
And looking at your response on the right-hand side, what was your response at the time in relation to the analysis that had been put forward by Fujitsu?
Yes, okay. So I say from the sample presented, the mean for software issues is 20 across the rest of the estate, but for Cleveleys it's 35. For network, the mean is 1 against 5 for Cleveleys. Software, the mean is 20 against 35, and hardware, the mean is 4 against 6. So what I say is that all of these issues are significantly higher for Cleveleys than the mean. So it's inconsistent with the statement that Fujitsu are making that Cleveleys is largely no better or worse than the rest of the estate.
So is it an accurate summary of your evidence now that, on the one hand, well, first of all, the figures themselves don't really help because they show lots of problems at lots of places?
Yes.
But second, to the extent that they do help, what they do show is that Cleveleys was actually suffering from a large number of software faults compared to others.
Yes.
Do you have any observations, again, now, having gained further experience of the system, your experience in the GLO, as to the response that was provided at that time by Fujitsu, the accuracy of the response or fairness of the response?
The consistently appears to be within Fujitsu and or Post Office a reluctance to ever really grasp the analysis of the issue and to look at it, and the times that this is that this comment about, you know, by design, double entry bookkeeping, the way that the audit logs are kept, all of these sort of principled issues are just repeated, when really it's often absolutely obvious that there has to be a technical problem that should be looked at. And I don't know whether it's an outward-facing position, this is what we say, but we will actually have a look at it, or whether it's this is what we say and we don't need to bother having a look at it. And I don't know which of those it actually is.
If we now look at operator advice to reboot, and if we scroll down on the right-hand side so that they match up, thank you. Can you tell us what you understand Fujitsu to be saying in this respect and your response to Fujitsu?
Yeah, so Fujitsu agree with me that it deals with the effect and not the cause, but they say that work goes on in the background and regular maintenance updates are made to address those problems. So the suggestion there is that they acknowledge that there are problems, that the system is then changed, and then an update is then rolled out. So theoretically, it should be better the next time, although there has often been cases where a fix has been rolled out that's then caused what's called regression problems. So it breaks other things that had been previously fixed when because of version control issues within the software.
So being told that there are fixes, is that helpful, or does it cause other issues that you might want to investigate?
Well, you see, whenever a fix is made within the software, you then have to understand what the impact of that fault actually was. And in order to look at the impact, you've got to know when did that version of software get pushed out to the estate, when did we fix it, and during that period of time, how many sub-postmasters have the potential to be impacted by that particular defect. And if there was an impact, you've really got to effectively rerun all of the accounts, or potentially make an exclusion that there was knowledge of a particular issue during that period, and therefore you certainly couldn't rely upon that data, certainly not for a prosecution, but you just couldn't rely upon that data because you don't really understand what the impact or potential impact on the data that defect might have had.
And again, knowing what you know now, your experience in the GLO, etc., do you have any additional views on this particular response from Fujitsu? Or is that the evidence you've just given?
No, I think I'm content.
Thank you. Moving down to defective equipment, again, can you tell us what you understood Fujitsu to be saying there and your response at the time?
So Fujitsu suggests that it was just simply a subjective view that I provided. But my response is that this is a tool for business. This isn't a home PC that might, at the time, might have got used, a couple of hours a day and got switched off every night. This needs to have a much lower level of defects and a much higher mean time before failure than the rest of the technology because of the criticality of it. So I said that I was confident in my statement that it was clearly defective.
And again, knowing what you know now, is there anything you would add to that?
Well, only that we know that there was a large number of hardware and interface problems that were seen, whether it be pin pads or printers or network devices, that have all suffered from problems that led to or had the potential to cause problems with postmaster accounts.
The next one, closing calls. I don't think that's actually addressed in your response, but are you able to assist us with what you understood Fujitsu to be saying there?
Yeah, so again, Fujitsu are referring to their own commercial agreement with Post Office, and rightly so. If they've got that agreement with Post Office, that's the way that they should operate. It doesn't necessarily correlate with the interests of the sub postmaster. So just Fujitsu saying, we're doing what we said we would do to Post Office doesn't really help the matter with Cleveleys suffering horrendous problems.
And if we scroll down on the left-hand side to the section on worrying discrepancies, I'm going to read you that first paragraph. It says, It's difficult to comment on the statement made by the expert in this part of the summary, although he is alluding to the fact that system errors may be responsible for this. I have explained why this cannot happen earlier in this report. The argument has been put forward by a number of postmasters in the past when challenged by Post Office Limited for unacceptable losses, and each time it has fallen when confronted by transaction data that demonstrates that the system was operating normally during the disputed period. Unfortunately, Fujitsu Services is unable to provide archived transaction data in respect of Cleveleys for the disputed period, as under the terms of the contract in force with Post Office Limited at the time, it would have been deleted from the archive 18 months after it was. And what was your response to that?
So what I said at the time is I'm unsure how this can be resolved, as clearly the PM reported discrepancies, and those discrepancies correlate with a reported upgrade in the system. So the suggestion is that the upgrade has led to these discrepancies. But I've said, without further information, I think you'd need an additional, witness of fact to be able to opine on that. If there's no documents or a system that I can look at, because I've been told it's not available, although we know that there was additional information that was available, then there's very little I can do with that. But then I conclude by saying, in short, the answer posed by your letter, and this was the letter from Susanne Helliwell, will I change my opinion? It is no. my opinion currently remains as set out in my original note.
The statement on the left-hand side that system errors can't happen, knowing what you know now, reading the precise words that are on the left-hand side, do you have any views on what's said there?
Well, I mean, absolutely, we know as a result of the work that was done in the GLO that system errors can be responsible for accounting issues, shortfalls. And in fact, we proved, and Judge Fraser agreed, that a number, I don't exactly know what the number was off the top of my head, but 25, 28 or whatever of the defects, had lasting impacts. So effectively all of the workarounds that may well have been put in place by Post Office to deal with the technical defects weren't successful, and it was lasting problems with accounts. And it's clear from the, well, I say recent disclosure. From my point of view, I only got the documents on Wednesday or Thursday of last week. There are references to peaks in those documents that I'm absolutely convinced were not disclosed to me as part of the GLO. So the number that we reported to the GLO of bugs, errors and defects may possibly increase with other disclosure.
I'm going to take you to one more response by Fujitsu, and that's WITN 04600206, please. And it may be that you didn't see this particular document. Are you able to assist us with whether you saw this or received this at the time?
No, I didn't see this at the time. This was provided to me by the inquiry.
Yes, it was certainly in your document pack that was provided. I'd like to just take you through each one of those headings and just see if anything that was said further internally at Fujitsu that wasn't received by you would ever changed anything.
Yes.
If you have a look at the first entry, so Horizon System Help Desk.
Sorry, Mr. Blake, is there a date on this document?
There's not a date on the document itself. I'm sure I can assist at some point by providing that date.
Thank you.
If we look at the third paragraph, it says, I've spoken to Jim Cruz, Post Office Case Manager, and we both feel that there's probably another opportunity to influence the expert's opinion by inviting him to Post Office account locations and providing him with access to data, records, and people who can deal with his observations directly. Is that ever an opportunity that was extended to you?
No. And I was told that there was no record that were available. It's only now where my opinion appears to be adverse, if you will, to them, that they're now suggesting they can set up people and documents that I can go and have a look at.
If you have a read yourself of that first entry, the Horizon System Help Desk, are you able to assist us with what you understand Fujitsu to be saying there, and whether that changes your position at all?
So, I mean, what they are simply saying is the restating the primary objective of the help desk is short-term and return the outlet to normal business as rapidly as possible. And certainly what we saw in the call logs was lots of reboots. Advice to reboot is the most effective way of doing that. It is not the function of HSS to analyse crash dumps while on the phone to postmasters, because crash dumps are one of the things that are typically created when a machine will blue screen, and that was experienced at Cleveleys. So I suggested I think in the first document that I sent, that I would analyse those crash dumps, but Fujitsu said that they've now been deleted, so they weren't available to me. But what he does go on to say here is that my comment regarding not getting to the bottom is flawed, and because he says that there is a KEL that was produced, at least for one of the calls, that shows that they were investigating things. And again, if that KEL had have been provided, it may well have been the case that my opinion would be have been extended to, whilst they are rebooting, I can see that there are KELs which show that further analysis was going on in the background, but that wasn't provided to me.
If we scroll down to transaction handling on reboot, again, are you able just to have a quick read of that and summarise it for us and tell us if that would have changed your opinion in any way?
No, it wouldn't have changed my opinion, and you know, I agree the way the system is designed, and if you went to test a system as I did as part of the GLO and tried to reboot and try and make it cause a transaction failure, you'd struggle to do it. You know, you might have to do this thousands or tens of thousands of times to get it to happen for you on demand, or then it might happen for a sub-postmaster 5 times in succession. That's just the way these issues occur. So no, there's nothing in there that would change my opinion.
Thank you.
I'm quite surprised that they say that the audit data would be deleted as quick as this, because I thought it was kept for a longer time. Maybe that's only changed in more recent times.
The next heading, reasonableness of calls. Can you assist us with that, please?
Yes, so...
And perhaps we can scroll over the page as well.
Yeah. So I think there appears to be a suggestion there that Fujitsu say that they could pull the raw data for the call logs, which was asked for at the time, but wasn't provided. But it would appear that data is now being suggested could be available, but only after my initial opinion has been documented.
And in respect of the dispute between the two of you with regards to the comparison data, do you have a view on what they say there?
So what's being said there is that there are other factors, including but not limited to training, competency, capability, and the PM's attitude towards raising calls. Interestingly, that list only includes the human factors rather than the technology factors or the differences in the types of transactions that post offices do.
Operator advice to reboot. Again, are you able to assist us?
So they acknowledge that I've asked for the crash dumps, but they've said they will have been destroyed. They offer for me to go, and it looks like some sort of walk. They're going to offer me a walk round to assure me of the support and problem resolution activity.
Would that have assisted you?
I mean, it might be of interest to see how it works, but when it comes to committing something to an expert report, then you really need to evidence the detail of this. So I'd really want to drill into what specifically was going on at Cleveleys. So going there and asking them to drill into the records at Cleveleys might have been interesting, but no, I wouldn't be convinced just by a walk around and an assurance.
The next one, defective equipment.
So the response here is that he would need to understand the basis of my opinion. Well, that opinion was formed from the call logs, and it talks about equipment being changed, which would suggest that somebody contemporaneously has determined that it was faulty, or blue screens. Blue screens is normally a hardware fault or perhaps software fault. So I think that's a reasonable assumption to make, that there was likely hardware faults.
And finally, on this document, they address your point on wiring discrepancies. If we could scroll down.
Yeah, so that appears that they haven't yet considered the specific calls that I referred to at that point in time.
Because it says we need to consider.
We need to consider the specific calls that the expert is referring to. So, I mean, the worry there is that they've made statements about how robust and resilient the system is generically, without actually going and looking at these particular issues that I raised. So that's potentially a failure there, really, and that they should have been considered in detail, presumably before this action was ever started.
Can we briefly look at FUJ 00121690? This is a covering letter, a covering email from Jan Holmes of Fujitsu to Keith Baines, Mandy Talbot, Susanne Helliwell, and others. Colin Lenton-Smith mentioned there as well. The date of this is 5th of August 2004, and it attaches further analysis that has been carried out as at this date. So we're now in August 2004. And if we look at FUJ 00121691, this is the further analysis.
All right.
Is this anything anything that was shared with you at the time, or anything that you were aware of at all?
It looks like that table is the same table, is it not? Headingley and Duncannon?
It certainly has the same post offices. There are slightly different statistics. It may be a slightly different period.
Right.
But is it? I don't believe that this is a document that you have ever seen.
I don't believe I've seen that document. No.
Thank you. Can we look at poll 00022842? This is the summary of bugs, errors, and defects from the Bates and others
Yes.
litigation. Can we turn over the page, please? If we look at number 2, calendar square, it is agreed the bug occurred between the years of 2000 and 2006.
Yep.
If we go down to number 9, reversals, this occurred for a short period in 2003.
Yes.
Number 10, data tree build failure discrepancies. Its identified effect was during 1999 and 2000.
Yes.
Over the page, gyro bank discrepancies, that's number 11. It occurred between May and September 2000. Number 12, counter replacement issues. The first was created in 2000. 15, phantom transactions.
Yep.
That arose in 2001. Number 16, reconciliation issues, mentioned in 2000. 18, concurrent logins.
Yes.
This occurred in 1999 and 2000. If we go over the page, number 22. Bugs, errors, defects introduced by previously applied peak fixes.
Yes.
Some of the peaks are from 2000. Thank you very much. Knowing that these bugs were present some during the period in which you were toing and froing with Fujitsu in respect of your expert report. Do you have a view as to the sufficiency of information that you were given during that Cleveleys case about bugs, errors and defects in the Horizon system?
Yeah, no, I mean, the information that I was given was deficient. That there was lots of information that would appear was available and had to be available because we've seen it or we saw it as part of the GLO, that simply wasn't provided to me.
Would knowing about those bugs, errors and defects that I've just highlighted in 2000, 1999, etc., would they have made a difference to your report in its strength of opinion or otherwise?
It may have been a longer report, setting the scene better, but I think ultimately my opinion was that the Horizon system as installed at Cleveleys was flawed. It had hardware, software and interface problems and had suffered from discrepancies. So my opinion wouldn't have changed. There might have been more underlying evidence that would have supported that ultimate opinion.
Do you have a view as to whether it should have been disclosed to you at the time?
Certainly, yes. My position is that all information that relates to defects, because this was a report about whether there was defects or not, should be disclosed. And I think that the question of relevance should actually be left with the person who's opining on it, rather than lawyers taking a view on whether something is relevant or not, because there is a danger that documents get taken out because they're considered as being not relevant, where if you had the technical context, you might be able to see that a document was relevant. In addition, I expressly asked for certain categories of documents, and they weren't provided. Well, I was told that it was destroyed.
Can we look at FUJ 00121724? This is an email that you won't have seen at the time, but it has subsequently been provided to you. It's from Jan Holmes of Fujitsu to Colin Lenton Smith and William Mitchell. It says, Colin Bill, following on from the Cleveleys outcome, what looks like the reappearance of Shobnall Road and the possible outcome of that case, I believe we should consider a risk position around litigation support. He then comments on the Cleveleys case. He says, although Cleveleys may appear to be closed, it could be construed that Poll bought off Mrs. Wolstenholme rather than defend their system. Even if a gagging order is placed on the woman, she apparently has a gaggle of postmasters lined up to support her case, and they'll be well aware of what the final outcome was. I'm sure that they will not be keeping quiet. It's not clear why Post Office chose to settle rather than fight, although I suspect they realised that to expose the HSH transcripts in court would not help their case. Personally, I can understand that position. Number two, Shobnall Road has come back. Bill has apparently been asked to provide a witness statement to the effect that nothing contained in the HSH calls over the period in question could have been caused or be described as a system malfunction. I'm attaching a brief analysis of the HSH transcripts that I did in April. Comments made by engineers that keyboards can cause phantom transactions do not help the Post Office's position. I suspect that we cannot make the statement required, and when Post Office read the transcripts in detail, they may well think that they could not submit them anyway. That reference there to an issue in Shobnall Road and keyboards can cause phantom transactions in that email of August 2004. Does that impact your view as to the sufficiency of information that you were provided with in the Cleveleys case?
I don't know what the particular issue was at Shobnall Road, but I'm certainly aware now of phantom transactions, and throughout the GLO there was a number of of documents that we looked at that theorised about whether keyboards could lead to phantom transactions. But certainly during the Cleveleys investigation, none of that was provided. And if that's thought to relate to Cleveleys, then that's significant.
If it isn't thought to relate to Cleveleys, but if it is an ongoing case at an approximate time in which reference is made to phantom transactions,
Yes.
Would that information have assisted you in your analysis of the Cleveleys case? Do you think it would or should have been disclosed to you?
Yes. It should have been disclosed. I mean, I expressly asked for call logs from other postmasters with a similar profile, I think the word that I used. So I would have thought that I would, should be able to distill something from that. Certainly, if anyone was aware of defects that was causing discrepancies at the time, those should be disclosed. And then the exercise that should follow from that is, once we're aware of what the defects are and how they lead to discrepancies, then attempt to demonstrate that Cleveleys was or was not subject to that particular defect. And that would have to be done across the whole estate, and certainly should have been provided to me by way of evidence.
Thank you. I want to ask you about a different topic very briefly, and that's ARQ data.
Yes.
A significant feature of the Cleveleys case is that there was no audit data available. Mm-hmm. Were you at the time aware of different types of data that might be available to you had it been available, had it been kept?
I'm not sure I would have been aware of the different types. I would have known just from general industry experience of accounting systems. I've created accounting systems myself, that there would be some sort of audit data, but I perhaps wouldn't have known it was called, or ultimately ends up being ARQ data. I don't think I would have known that at the time.
We've heard, and we will no doubt hear more about differences between a standard ARQ extract and raw data from
Yes.
the audit store.
Mm-hmm.
What would you have wanted to have seen had you had the opportunity in the Cleveleys case?
So for the particular transactions of interest or days of interest that you can determine from looking at the call logs, the expectation would then be, or the next request would then be, can I have a look at the transactional data for those days, which would show me the transactions in accounting terms, and then from that look at the audit data that's behind those transactions to try and determine whether something's gone wrong with the posting of the transactions or systematically from the back end.
Are you able to assist us at all, and you may not be, whether filtered ARQ data is something that you would have been satisfied with in this case, or whether you would have wanted to see more?
I would never be satisfied by seeing filtered anything without understanding what filtering has gone on. The danger is with any filter, well, what has been taken out? So my preference would always be to go for the raw data, and then I will filter myself based on what I see fit.
Knowing what you know now, do you have any concerns in that particular regard?
Well, I certainly know that filtered and unfiltered data was a feature in the GLO, and there was problems then with the filtering as such about what was left out. But then there is a factor that I just noted in the documents that were disclosed, certainly disclosed to me only last week, that relates to a discovery that the ARQ data itself has duplicates within it. So it shows that transactions have been duplicated in the ARQ data. And this is a report I believe from Penny Thomas and Gareth Jenkins, and it refers to 2 peaks, the numbers of which I don't recognise. And it also refers to 2 specific post offices that were involved in some form of litigation or criminal action at the time. So it would appear that as a result of pulling the ARQ data, perhaps, and I don't know this for a fact, but perhaps to support the litigation or whatever it was at the time, they discovered that ARQ data was incorrectly showing duplicate transactions. Now, the potential impact that flows from that could be huge, but without investigating it further, I don't know. There is a peak number. There's 2 peak numbers listed in there.
It is a matter that we'll be dealing with other
Right.
witnesses in due course. Finally, I'd just like to take you to a few criticisms that were made by Fujitsu and by the Post Office in respect of your report or you acting as the expert in the Cleveleys case. Can we look at FUJ 00121561, please? Thank you. So this is an email from Jan Holmes to Colin Lenton Smith, and he says, draft email to Jim Cruz for you to consider. I've transferred the contentious statement from the paper to the email because it's not in our interest to piss the expert off. That said, it has to be pointed out to Jim that his report is far from impartial, and in truth, we have a problem because there's little we can do to dispel some of the assertions other than say rubbish. I want to take you to one more document before I ask the question, and that's FUJ 00121747. This is a subsequent report on the Cleveleys case, and it was written by Jan Holmes. Can we look at page 4, please, of that report? And it's halfway down under 3.1. He says there, the expert who was supposed to be jointly appointed has taken a very one-sided view of life and has drawn conclusions that are based on a paper review of HSH call logs covering the period from initial rollout of the office to November 2000. In some cases, his analysis of the call logs is incomplete and stops at the point where it supports his opinion. What's your view of those comments that were made by Mr. Holmes?
I mean, certainly, I dispute that, taking a one-sided view of life. Part of my training, and it's a constant focus in what I do, is I have to take a very balanced view. And certainly when it's a joint expert report, you have to make sure that everything that's available from the parties has been considered. So I completely refute that view. And the fact of the matter is, I did only do the paper review because that was the only information that was said to be available to me. He's obviously got other additional information that wasn't disclosed to me.
And finally, similar points made by the Post Office. It's poll 000311815. This is a PowerPoint presentation by somebody called Dave Smith, who was the IT director at the Post Office. And if we look at page 3 of this presentation, he addresses the Cleveleys case. And he says there, solicitor appoints expert. Expert was not challenged or managed. Expert assumed status of joint expert, produced a report which, in my view, exposed the expert as a sham. Nonetheless, expert concluded that Horizon could have caused the discrepancy. Did not have access to audit trail, so couldn't refute. That is proof that what the expert said could happen didn't happen. Are you able to give us your view on that opinion?
Well, I mean, I believe it's delusional to then look at evidence and simply say that isn't correct. And I looked at the evidence and I said what my opinion was and still remains that system was absolutely flawed at that point in time, and throughout the GL, we proved, and Judge Fraser agreed, that that system had a large number of bugs, errors and defects. If Fujitsu aren't going to look at the detail of the evidence, or they're going to look at the evidence and then say they have a different view of it, I do believe that's a delusional view. They just fail. They fail either to consider it, or their opinions are flawed when looking at that evidence. Or alternatively, from Fujitsu's point of view, they're looking at it from a commercial lens, that all they need to do is satisfy Post Office. They don't have any real primary interest in satisfying postmasters.
Finally, are there any other matters relevant to the Cleveleys case that you think should be drawn to the attention of the chair?
No, not relevant to Cleveleys. No.
We may well have you back in phase
Yes.
5 to address issues relating to the group litigation.
Mm-hmm.
So before I ask whether any core participants have any questions, do you have any questions?
No, thank you very much. No.
I don't believe there are any questions from any core participants, so we are finished.
Thank you very much, Mr. Coyne, for coming to give oral evidence and for making a witness statement in advance. As you will appreciate, I have read a great deal of what you've had to say in many different contexts. So it's nice to put a face to the voice, so to speak. Thank you.
Thank you.
Thank you, sir. Can we take a 15-minute break until 12:10, and then we will hear from Ms. Helliwell?
Yeah, and I'm very sorry that there's a sort of hard end point at 2 o'clock, so that even a few minutes, I'm afraid, we can't go beyond it, but I know that you manage it very well, Mr. Blake.
Thank you. It's actually Miss Price who will be managing it very well.
Ah, well, then
Even
we have
better.
a new one to manage. Thank you.
Thank you.
Sir, can you see and hear us?
Yes, I can. Thank you very much.
Thank you. May I call Ms. Helliwell, please?
Yeah.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Miss Thanks.
Good afternoon, Ms. Helliwell. My name is Emma Price. As you know, I ask questions on behalf of the inquiry.
Yes.
Could you give your full name, please?
Susanne Jane Helliwell.
Thank you for coming to the inquiry to assist it in its work and for providing a witness statement to the inquiry. We are very grateful. You should have in front of you a hard copy of a witness statement in your name,
Yes.
dated the 14th of July 2023.
Yes.
And if you turn to page 7 of that statement,
Yes.
is that your signature?
Yeah, my signature's been removed, obviously, but I did sign that statement.
Are the contents of that statement true to the best of your knowledge and belief?
Yes.
For the purposes of the transcript, the URN is WITN 09420100. There is no need to display that. Today, I'm going to be asking you about issues which arise in phase 4 of the inquiry, focusing on action taken by the Post Office against sub-postmasters and others, and in particular upon the proceedings brought by the Post Office against Julie Wolstenholme in relation to her time as a sub-postmaster of Cleveleys sub-post office. In terms of your background, you were admitted as a solicitor in 1990, is that correct?
Yes.
Where did you practice when you first qualified?
When I first qualified, I practiced at a small firm in Manchester called Shammer Nichols.
And around 10 years after being admitted as a solicitor in January 2000, you became a solicitor at Waitman Wizards, is that right?
Yes.
And which team at Waitman's did you first join?
I first joined the commercial litigation team, as it was known then. And then I had done some employment work at my previous firms. So I moved more into employment over time. So I did a mix of commercial litigation and employment work.
And which team were you in at the point you became involved in the Cleveleys case?
I believe then I was still doing a mix, but I'd moved more to employment, but I was still doing a mix of commercial litigation as well.
And you remained employed with Waitman's until around July 2005?
Yeah, that's yes, to the best of my recollection, it was around then.
And then you had for around 4 years, you were away from the practice of law, running your own business.
Yes.
And in 2009, you went back to practice as a solicitor with a firm in Manchester, is that right?
Yes, that's right.
And you left to take on a consultancy role to that firm in 2019, a role you remain in now.
Yes, that's right.
Before the Cleveleys case, had you been involved in any other cases on behalf of the Post Office?
I believe that I may have had some involvement in some employment cases, but I can't. It's just the timing it's just very difficult to think of the timing. But I believe that I may have had some involvement, or it may have coincided with me having some involvement on employment cases for the Post Office.
And did you have any knowledge of the Horizon IT system before becoming involved in the Cleveleys case?
No, not as far as I can recall.
You have explained in your witness statement that proceedings against Mrs. Wolstenholme were initially issued and dealt with by the Legal Services Department of Consignia plc. Is that right?
Yes.
We have a copy of the trial bundle prepared for the Cleveleys trial, which was listed in August 2004. Could we have on screen, please, trial bundle A from that, which contains the pleadings in the case, the references POL 0011 8218. Starting, please, on page 3 of that document using the external electronic numbering. We have the claim form, and towards the bottom of the page, please, we have the issue date here of the 23rd of April 2001. We can see about halfway down the page brief details of claim, delivery up of goods belonging to the claimant, and going over the page, please, the statement of truth on the claim form towards the bottom. And this is signed by James Cruz, said to be a senior lawyer at Consignia plc Legal Services. Could we go over the page again, please? These are the original particulars of claim, is that right?
Yes.
And over the page, please, to the second page of those particulars. We can see at the bottom that these are dated the 19th of April 2001, and again, the statement of truth is signed by James Cruz.
Yes.
You say at paragraph 5 of your statement, I don't think we need to turn it up, that you would have become involved in the case at some point after the issue of proceedings in 2001 and prior to the preparation of the amended particulars of claim in February 2003. Should we understand from these documents that as of the 19th of April 2001, the date of the original particulars of claim, Waitman's had not yet been instructed on the case?
I believe so. I believe that we were instructed subsequently and that they might have been dealing with it, I assume dealing with it in-house.
Could we turn, please, within this bundle to external page 87? This is the Notice of Transfer of Proceedings dated the 11th of June 2001. And we can see that this is addressed to the claimant's solicitor, identified as being Consignia Legal Services.
Yeah.
So it seems as though the matter was still being dealt with in-house at this stage on the 11th of June 2001.
Yes.
Turning please to page 98 of the bundle. This is the Notice of Allocation or Listing hearing dated the 16th of July 2001. And we can see here the claimant solicitor is here identified as Waitman. So would we be right to understand by this that by the 16th of July 2001, Waitman Visits was on record as acting for the Post Office?
Yes.
Could we turn back, please, to page 5 in this document, the original particulars of claim? Looking at paragraph 3, please. We can see the description here of a number of items and equipment, including 2 safes, Horizon computer equipment, an alarm system and some scales, and then estimates of value of these items at paragraph 4. Then at paragraph 5, we have this. Expressly or by implication, the defendant agreed that she would deliver up to the claimant and/or would permit the claimant to collect the said items and equipment on demand and/or after termination of the said contract and/or after cessation or use of the said premises as a sub-post office and/or within a reasonable period of time, such demand or termination or cessation of use. Turning over the page, the background to the dispute is provided, and then at paragraph 8 we have this. The defendant has refused to deliver up the safes and other equipment or permit the same to be collected. And about halfway down the page, we can see what the claim was for, delivery up of these items and equipment or their value in damages. So it's right, isn't it, that the original claim brought by the Post Office related only to the recovery of items and equipment or their value in damages?
Yes. Could I just correct one small thing that I mentioned before about which department I was in at the time that Waitmans became involved?
Of course.
Just having seen the fact that our name appeared on the notice back in July 2001, at that stage I would definitely have been just in the commercial litigation department.
Thank you. Turning please to page 8 using the external pagination. This is the defence and counterclaim on behalf of Mrs. Wolstenholme. And paragraph 2 of that reads as follows. In relation to paragraph 2 of the particulars of claim, the defendant admits that she was a sub-post mistress, but she contends that on its true construction, the contract between her and the claimant was a contract of employment. The defendant asserts that her employment was terminated unlawfully, and she has made an application to the Industrial Tribunal for unfair dismissal. And in that claim, she has claimed re-engagement and reinstatement at the premises in Cleveleys where she was carrying out her employment. So Mrs. Wolstenholme raises here the ongoing employment proceedings she had brought against the Post Office for unfair dismissal.
Yes.
And over the page, please, to paragraph 5 of that document, which reads, paragraph 5 of the particulars of claim is denied. In the alternative, it is necessary for the said items to remain in the said premises until the determination of the disputes between the parties. We see here Mrs. Wolstenholme's response to the claim. She denied that she had agreed to surrender the items and equipment. Alternatively, it was necessary to keep them for those reasons. Then over the page again, please, at paragraph 14. Further, or in the alternative, it was an implied term of the contract between the claimant and the defendant that the computer system provided by the claimant would be fit for its purpose, and the claimant is in breach of this term in that the computer system provided was unfit for its purpose, and the claimant failed to ensure that the system was working adequately. The defendant has supplied the claimant with details of the persistent inadequacies of the said computer system. It's right, isn't it, that Mrs. Wolstenholme was raising, as part of her counterclaim, an allegation that the computer system in her branch was unfit for purpose and that the post office had failed to ensure that the system was working adequately?
Yes, she has. She's raised that allegation.
Turning please to page 93, using the external pagination. This is the reply and defence to counterclaim. Could we have please page 97? Scrolling down a little, we can see that this document appears to be dated 2001. It's no more specific than that. And there is a statement of truth. Going up a little, please. Signed by a solicitor named David Robert Jacks. Waitman's name and address appears beneath this. Was David Jacks a fellow solicitor at Waitman's?
I believe he was a partner at Waitman's. But he may not have been at that time because he describes himself as a solicitor, but I believe he was a partner.
Can you help us with whether you were the file handler on this case from the start, when Waitman's were first instructed, or whether the file was transferred to you at a later date?
Is it possible to just go back to the notice from the court where Waitman's appeared? Because
Of course.
that could have the reference on it.
So this is page 98 of the bundle. Notice of allocation or listing hearing. Was this the order you were looking for?
Yeah.
16th of July 2001.
Yeah, at that stage, it's just David Jack's reference. My name doesn't appear on it, and it would have done if I was the file handler at that time.
Does this help you date your involvement at all?
Possibly, because, sorry, but could you just go back to the document that you were in before? Was that the reply and
Yes,
defence
that's
to
page
counterclaim?
93, please. And the last page of that, sorry, is 97.
Yes, so I think that I probably, I wouldn't have been involved at that stage. And again, to the best of my recollection, I may have become involved when we dealt with the amended, just before we dealt with the amended particulars of claim was it February 2003? Because again, with the proceedings stayed for a period of time after this, I can't remember the exact dates, but the proceedings were stayed, and then I think the first time my reference comes into play is more around 2003.
When you did pick up the file, presumably you would have read the pleadings that were on file.
Yes.
And just looking then, please, at the substance of the reply and defence to counterclaim. This is page 95, please. At paragraph 3, we can see here the Post Office's case in relation to whether or not the agreement was lawfully terminated.
Yes.
And we can see here 3.1, the defendant knew well and accepted that the claimant had given lawful and proper notice of termination of the said agreement and offered a payment in lieu of the 3-month notice the defendant was entitled to under the written agreement. The said sum was calculated from the date of suspension of the defendant, 30th of November 2000, with the last date of service identified as the 28th of February 2001. 3.3, the defendant normally would have received £19,322.85 in commission for this period, due to the fact that there were outstanding losses incurred by the defendant, £17,825.37, and for which she was liable to make good to the claimant paid the balance or excess of commission or remuneration to the defendant in the sum of £1,497.48. So the Post Office was suggesting that there were outstanding losses incurred by Mrs. Wolstenholme, which was why she was not paid the full commission she would have received in the 3-month notice period. Is that a fair reading of that?
Yes, it seems to be, yeah.
And then at paragraph 4, please. It is denied that the said computer system was unfit for its purpose, and it is averred the same worked adequately. Would you agree that it is clear on the face of the pleadings we have been through so far, all dated 2001, that an issue in the case from the outset was whether the computer system in the Cleveleys branch was fit for purpose and worked adequately?
Yes, I'd agree with that.
Could we have on screen, please, WITN 090 20113? This is a draft letter exhibited by Julie K, née Wolstenholme, to her witness statement provided to the inquiry. We need not have her statement up on screen, but the reference for the witness statement for the transcript is WITN 090 20100. This document is referenced at paragraph 9 of that statement, and it is her evidence that this was drafted by her father. Could we have, please, the second page of that document? 3 lines down. On the 28th of August 2001, we wrote via solicitor to Waitmans for logs from June 2000 to I think that's NO 2000, never received. I wonder why. It may be that you can't help us if you believe you were involved later, but were you ever aware of a request in 2001 on behalf of or from Mrs. Wolstenholme for call logs?
No, I wasn't, no.
At any stage before the particulars of claim were amended in February 2003, did anyone at Waitman Vizards ask the Post Office for records of any reports made by Mrs. Wolstenholme of problems with the computer system? I know you may be slightly limited by what you would have picked up if you took that file on later, but were you ever aware of such a request before February 2003?
I can't recall, to be truthful, I can't recall. It's 19 years ago, or more, isn't it then? But I just can't remember.
We have a number of court orders in the trial bundle which provide some insight into the progress of the proceedings after the reply and defence to counterclaim was filed on behalf of the Post Office in 2001. Starting, please, with page 98. And this is going back, please, to the trial bundle. Poll 001 18218. And that's page 98. This is the order we've looked at already of the 16th of July 2001 for the purposes of trying to date Waitman's involvement. And we can see here that an allocation hearing is being listed. Over the page, please. We have the order of the 30th of August 2001. This appears to be an order made following the allocation hearing.
Yes.
As far as you're aware, were you involved at this stage in August 2001? If we can just scroll down a little so we can see the directions there.
I don't believe I was, because again my reference doesn't appear. on the order.
Do you have any recollection of there being a direction at one stage in the proceedings giving permission for both parties to rely on one expert each in computer systems?
I actually don't. My recollection is that there was an order was made for a joint expert. When I saw this, I don't have any recollection of that. It was obviously before my involvement, and I don't think it was ever really acted on, was it? Because the proceedings were stayed.
We'll come in due course to that order you're thinking of in terms of the single joint expert direction. Over the page, please, to the order of the 11th of March 2002. We can see the case management conference, which had been listed, being adjourned to May. Over the page again, the 14th of May 2002. Again, we have an adjournment to June 2002. Over the page again, please. The order of the 14th of June 2002. We have another adjournment to July 2002.
Can I just, my reference then appears on that order, doesn't it?
If you can just indicate where you see your reference.
This is the general form of judgment or order of the 14th, dated the 14th of June 2002. Mm-hmm. My reference appears in the claimant's reference. The reference to NJK was the partner, head of commercial litigation from memory in Liverpool.
Okay, and who was that individual?
Neil Kelly.
And how do you spell that surname?
K-E-L-L-Y.
Just going back, please, one page. So your reference doesn't appear on that May 2002 document, and it does for the first time.
Yes.
On the next page, please. 14th of June 2002. So does that help us pinpoint then when you became involved?
Yes, it does. Yes.
If we can go over the page again, please. This is the order of the 5th of August 2002. We can see the claim is stayed until October 2002. And paragraph 2, please, of the directions, just a little further down the page. Upon termination of the stay, the claimant's solicitor shall, within 14 days of termination, write to the court explaining the position in relation to the hearing before the EAT, and the court shall then consider whether to list for a case management conference or whether to order a further stay. So it would appear that there were a number of adjournments and then a stay, seemingly because of the ongoing employment and then employment appeal tribunal proceedings. Do you recall that being the case?
Vaguely, having read the bundle, the trial bundle, it did come back to me that there was a stay for a period of time, yes.
If we could turn, please, to page 104. We come now to a directions order of the 14th of February 2003. And just looking at the recital there, it appears that a hearing took place at which the claimant was represented by a solicitor from Waitman Wizards. Was this you?
I can't specifically recall, but I believe it would have been me.
And it appears here that the defendant was in person at that hearing.
Yes.
And we can see from paragraph 2 here that permission was given for amended statements of case from the Post Office and permission for an amended defence and counterclaim. And the order records that Mrs. Wolstenholme's claim and appeal to the Employment Appeal Tribunal had been dismissed. And then at paragraph 8, we have this. On it appearing to the court that expert evidence is needed on the issues of liability, causation, and that the evidence should be given in the form of written reports of a single expert jointly instructed jointly by the parties in the field of computer technology. What can you recall, if anything, about the change in the directions in the case from each party having permission to rely on its own expert to the direction for a single joint expert?
I don't really recall why that happened. It may have, I'm guessing, but it may have been that there was more of a move towards a single joint expert. Maybe previously parties have been each allowed to rely on their own expert, but there was, I don't know when the shift was, but there was a shift to the courts, going more along the single joint expert approach. So whether it's that, I don't know.
And can you recall now what the Post Office's position was on whether each party should have its own expert or whether there should be a single joint expert? I know it's difficult after so much time.
I can't recall. No, I can't recall, I'm afraid.
Could we look, please, to the amended particulars of claim, which is page 13 of this bundle, using the external pagination. We can see here the particulars were amended pursuant to the order of Deputy District Judge Lambert, which we have looked at. Turning, please, to page 15. Scrolling down to the bottom, please. We can see your name and signature on the statement of truth on behalf of the Post Office.
Yes.
Were these amended particulars drafted by counsel? It may assist if you scroll down, if we scroll down a little more.
Yes, I think they were. Is it Tina Raniales-Kotos?
And just scrolling down a little more, please.
Yes.
Looking then at the new paragraphs in these particulars, page 13 again, please. Starting with paragraph 3. A copy of the contract for services is attached at pages 1 to 60. The claimant will rely on the contract for services for its full terms and effect at trial. Paragraph 4. In particular, pursuant to section 9M, paragraphs 12 and 13 of the contract for services, the defendant is liable for losses arising at the defendant's post office during the period of the contract of services. The defendant's sub-postmaster's account shows an overall final loss in the sum of £25,034.04 in respect of the period up to and including the 4th of December 2000. An itemised, over the page please, breakdown of this figure is attached at pages 61 to 67. Such sum remains outstanding to date. Over the page once more, please. Paragraph 13 reads, further, the defendant is indebted to the claimant in the sum of £25,034.04, which represents the overall final loss figure on the defendant's sub-postmaster's account, and the claimant claims such sum. It's right, isn't it, that the Post Office was no longer limiting its claim to the return of equipment. It was also seeking payment of the sum of £24,034.04, a sum it claimed represented losses in the Cleveleys branch, which Mrs. Wolstenholme was liable for under her contract for services.
Yes.
And the Post Office was relying upon section 9M of the contract, and in particular paragraphs 12 and 13, which was appended to the amended particulars of claim. Could we have, please, page 45 of this bundle? Paragraphs 12 and 13 read as follows. The sub-postmaster is responsible for all losses caused through his own negligence, carelessness or error, and also for losses of all kinds caused by his assistants. Such losses must be made good immediately. The financial responsibility of the sub-postmaster does not cease when he relinquishes his appointment, and he will be required to make good any losses incurred during his term of office which may subsequently come to light. There is no reference, is there, in the particulars of claim, the amended particulars of claim, to the losses alleged by the Post Office having been caused by Mrs. Wolstenholme's negligence, carelessness or error, is there?
Sorry, could you just repeat that?
Of course. So the particulars of claim, the amended particulars of claim we've just looked at, it contained a bold statement that Mrs. Wolstenholme was liable under the contract for the losses.
Yes.
But there was no reference there, was there, to those losses having been caused by Mrs. Wolstenholme's negligence, carelessness or error?
Not in that document, no.
Did this reflect your instructions at the time that sub-postmasters were liable for all apparent losses in branch, regardless of the cause of those apparent losses?
Yes, it did.
At the time that the particulars of claim were amended, were you asked to advise on the contractual position on liability of sub-postmasters like Mrs. Wolstenholme for apparent losses or shortfalls occurring within their branch?
I don't recall.
Moving then, please, to the amended defence and counterclaim, page 88, please. We can see here that the title of defence has been amended to re-amended defence. And looking at the first page, scrolling down a bit, please, we can see an amendment to the paragraph numbers to reflect the new numbering in the amended particulars of claim, a change to paragraph number 6, so at paragraph 3 there. And over the page, please, we see some further changes to paragraph numbers. The paragraphs dealing with the new aspects of the Post Office's claim, that is the claim for losses to be paid, were paragraphs 3, 5 and 13. Just scrolling down, please, to check. They don't appear to be referenced, do they, in this re-amended defence?
No.
And just for completeness, turning to the last page of this document, page 92, please. This document is dated the 14th of April 2003. External page 110, please, in this bundle. This is the order of District Judge Bryce, dated the 7th of July 2003. And it appears from the recital that, again, a solicitor from Waitman's attended this hearing on behalf of the Post Office. Was this you, do you think?
I believe if I'd have, unless was on holiday or anything like that, it probably would have been me that attended that hearing.
And we can see the first direction here reads, claimant due by 4 p.m. on July 21st, 2003, serve on defendant copies of all of relevant computer logs from June 2000 until November 2000. Does this direction tell us that the Post Office had not, up to this point, provided Mrs. Wolstenholme with the computer logs for this period?
Yes, it does tell us that.
Can you help at all with why that was?
I'm afraid I can't recall. It may be that we had been asking for them, but without seeing my correspondence to the Post Office around this time, I just can't recall.
At point 4 of the directions, please. It appearing to the court that archived material on the computer may have been destroyed, it is directed that A, claimant solicitors so make further inquiries and copy any correspondence to defendant. And B, I think that is, parties make inquiries of expert as to whether an opinion can be given using only computer logs. So were these your instructions at the time in relation to archived material, that they may have been destroyed? There appears to be some uncertainty about that.
Yes, it would have been my instructions at the time, and we were probably trying to make inquiries just to see what had happened, and that's why that direction was given.
That document can come down now, thank you. Is it right that this material, the archived material, was held by Fujitsu and not the Post Office?
Yes, as I understand it, yes.
Looking then to what steps were taken by and on behalf of the Post Office following this directions order, may we have on screen, please, the second part of Trial Bundle C, which is the documents bundle. The reference for that is POL 00118221. And if we could turn to external page number 217, please. This is a letter to you dated the 24th of July 2003. And going over the page, please. Down to the bottom, please. We can see this is from Jim Cruz. Was he your primary legal services contact at this time?
Yes, he was.
And we can see from the first paragraph, going back to the first page, please, that this letter addresses the court order of the 7th of July 2003 and computer evidence in particular. The next paragraph sets out the basis on which computer equipment was provided by Fujitsu. Then 2 paragraphs down, starting the Horizon system. The Horizon system went live at Cleveleys on the 10th of February 2000, and the sub-post office at Cleveleys closed on the 30th of November 2000. It is understood that the computer equipment was left plugged in and running for some time after the office closed, and the data would therefore have been archived. Fujitsu services have informed Post Office Limited that their technicians would not be able to retrieve the data in these circumstances. The next paragraph deals with data which would have been held by the data warehouse, which would have been kept for 13 weeks. And then over the page, please. Beyond the data warehouse, Fujitsu have a message store which holds greater detail. This detail is held for 35 days in an accessible area, and after that time it is archived. I have been informed by Fujitsu that prior to the 1st of April 2003, this detail was only held for 18 months. The position is now that since the 1st of April 2003, Fujitsu hold message store information for 7 years. However, no transaction details are now available and accessible for the period 1999 and 2000. Some emails appear to have been attached to Mr. Cruz's letter, and those appear over the page, please. And starting, please, at the bottom of the email chain, which is page 220. Scrolling down, please. The first email in this chain is from a man called Reg Barton, writing to Kevin Parkin at 8:35 on the 4th of July 2003. The first line reads, I understand that POL have been raising some questions about Cleveleys' SPSO. He goes on to explain the position in relation to Horizon equipment and the data warehouse. Going back, please, to page 219, just one page. About 2/3 of the way down the page, there is an email from John Moran. He addresses the position in relation to the data warehouse and the message store. And then over to the top of the next page, please. In any case, it would appear that any date in 2001 is well beyond the 18-month threshold. Thus, there is nothing we can do on this one. Was it your understanding at the time from these emails that this was the first time the Post Office had tried to obtain any data relating to the relevant period at the Cleveleys branch in early July 2003?
It's certainly the first time I'd have raised it with, or around the first time I'd have raised it with them. I'm not sure whether it had been raised with them before then.
Before we move to a different document in this bundle, just going up, please, to the top of page 219. It would seem that by this point, Mandy Talbot from Legal Services had at least some involvement in the case, because she's at the top of that email chain. Was there a time when both Jim Cruz and Mandy Talbot were involved in the case?
There may have been. I'm just trying to remember Mandy Talbot's position at that time. Was she Jim Cruz's? Was she senior to Jim Cruz?
We know from correspondence that she is described as his boss, in effect.
So maybe she had some involvement. I don't know. But it looks obviously as though she did have some involvement.
Could we have, please, page 47, still within this bundle? This is a letter from you to Mr. J. Coyne from Best Practice Group. That is Jason Coyne, the single joint expert in the case. Is that right?
Yes.
And it's dated the 3rd of September 2003. And you set out in that first paragraph the background to the matter.
Yes.
And then over the page, please. You provide the history of the contact between your firm and Mr. Coyne. Is that right, that the first contact was in June 2003?
I believe it would have been, because that's when I referred to it in the letter.
Can you recall how the Best Practice Group and Mr. Coyne specifically came to be approached as a potential single joint expert?
I can't specifically recall, but at that time, I'd have looked at suitable experts in that field. That's the best information I can give, unless he was recommended by somebody.
Then 3 paragraphs down, you explain that you're enclosing the letter that we've just looked at of the 24th of July 2003. So that's the 4th paragraph on the page. We enclose a copy of the letter from the Post Office to this firm, dated 24th of July 2003.
Yes.
And you continue, we're writing to you for the purposes of ascertaining whether you would be able to provide an expert report, having had sight of only the computer logs and having not had an opportunity to inspect the computer system. And finally, on the last paragraph, you enclose the computer logs. So we accordingly enclose copies of the computer call logs between January 2000 and November 2000. Just pausing there, the information which was provided to you by the Post Office and which was passed on to the expert was that in 1999 and 2000, archived material was held for 18 months.
Yes.
So had a request for archived material in the message store been made in June 2001, when the Post Office received Mrs. Wolstenholme's original defence, then material going all the way back to January 2000 would, on this estimate of time, still have been available?
On this estimate, it would have been, yes.
In terms of why such a request was not made, Mrs. Wolstenholme raised this point in correspondence with you in November 2003 and then January 2004. We need not look at both letters as the point is restated in exactly the same terms in the second, but if we could have, please, page 231 in this bundle. This is a letter dated the 21st of January 2004 to you. The penultimate paragraph reads as follows. Why, when it was obvious in December 2000 that this case was going to be pursued through court, were all computer details destroyed? And if we can go over the page, please, page 232, we will find your response dated the 26th of January 2004. And over the page again, please. At point 5, we find your response on this particular issue. And you say, proceedings were commenced by our client in April 2001, seeking only delivery up of the goods and equipment at the former post office premises following your suspension in November 2000. The fitness of the computer equipment was referred to in your defence and counterclaim received in June 2001, and therefore it is therefore not correct to state it should have been obvious to our client in December 2000 that this was going to be an issue. As we now know, the computer records were only kept for a limited period at that time under the procedures then existing. Unfortunately, it was not apparent to our client's representatives at the time that the computer records would feature so heavily in the preparation of the case. Further, you did not at any time request that they be preserved. Who were you referring to when you described your client's representatives at the time? Were you referring to Royal Mail in-house legal services or Waitmans?
Royal Mail in-house legal services.
And were these your instructions that the post office had not appreciated that the computer records would feature so heavily in the preparation of the case?
Yes, they were my instructions. They would have been, the letter would have been written in accordance with those instructions.
Did you find it surprising that nobody within Post Office had recognised the need to obtain computer records upon receipt of Mrs. Wolstenholme's defence in June 2001?
Did you say, do I find it, or did I find it?
Did you then and do you now?
To the best of my recollection, I do recall being surprised that there were no records available. Surprised and probably frustrated.
With hindsight, should your firm have recognised the need for Post Office to obtain computer records in this case when the firm was first instructed in July 2001?
It's difficult because obviously I wasn't involved at the time, and I don't know what information and on what basis we were instructed. I also don't know whether the person that dealt with it before me made a request to the Post Office. So it's difficult for me to comment on that.
Of course. There was some further correspondence between you and Mr. Coyne before he provided his opinion, wasn't there? So Mr. Coyne replied to your letter of the 3rd of September 2003 on the 19th of September 2003, and this is within the bundle we're currently looking at external page 49, please. If we can scroll down a little bit, please. And so Mr. Coyne is effectively asking in this letter for clarification, further information and instructions, isn't he? I think you've had a chance to see this letter before.
Yes.
And then you wrote to Mr. Coyne on the 17th of November 2003 before he provided his opinion, enclosing some further documentation. So may we go to that letter, please, page 50 in this bundle?
Yes.
And the first line there, we refer to your recent telephone conversation with our Miss Helliwell, and in that regard, we enclose the copies of the following. So the letter appears to have been sent following a telephone call that you had with Mr. Coyne. Do you recall now what you discussed with Mr. Coyne during that telephone call?
I don't. It was virtually 20 years ago.
Of course. We can see here that you enclosed those documents listed below, including the witness statements being relied upon by the Post Office and Mrs. Wolstenholme.
Yes.
You refer to the background to the case set out in your previous letter. And just scrolling down a little, please. There is a reference to the comparable call logs that Mr. Coyne had asked for, and then we have, as you are aware, the last paragraph there.
Yes.
Our client has unfortunately been unable to obtain a set of comparable call logs, and it has therefore been agreed between the parties that copies of the pleadings, witness statements and relevant documents in the proceedings would be provided to you for you to assess, with a view to confirming whether you would be able to provide a report which would be of value to the court, and if so, detailing the matters upon which you would be able to report. Was this letter and your previous letter to Mr. Coyne, dated the 3rd of September 2003, the extent of your instructions to Mr. Coyne, as far as you can recall?
As far as I can recall.
Do you recall whether Mrs. Wolstenholme had any input into the instructions provided to Mr. Coyne?
I think she would have had to have some, she would have had to have some involvement because it was a joint instruction, and I refer to that in my correspondence. Is she copied into my letter or not?
If we can scroll up to the top, please. Not on the face of that letter.
There's nothing at the end of it then.
If we can just scroll down and go over the page, please. And just scrolling down a little further, please.
I can't recall, but it's a joint instruction, so she would have had to have had some involvement, and I refer to agreement being reached between the parties for the expert to report as far as if to the extent he is able. So that would obviously assume that she has had involvement and has seen correspondence, but I can't be certain just because of the time.
The inquiry does have documentation indicating that it was a joint instruction. It was just in terms of the content of that letter. But if you can't recall.
I can't recall.
One of the documents which was sent to Mr. Coyne was a witness statement from a lady called Elaine Tagg, who was Mrs. Wolstenholme's retail line manager. You say in your statement to the inquiry, at paragraph 13, little Roman numeral 5, that to the best of your recollection, you were involved in the drafting of the witness statements of Keith Baines and Jan Holmes. You have fairly recently, I know, had the opportunity to refresh your memory as to the content of Elaine Tagg's statement, dated the 16th of October 2003. If we can have that, please, on screen. That's Pol 0011 8219. That is external page 5, please. If we could scroll down a little more. To the best of your recollection, were you involved in the drafting of this statement?
Yes, to the best of my recollection, I would have been. I was. I obviously hadn't recalled because I didn't have the document and I couldn't remember who the witnesses were. So my statement was based on the documents that I had at that time.
Of course. This statement addresses the call logs which are exhibited to the statement by Ms. Tagg. Did you yourself do any analysis of the call logs for the period the 10th of January 2000 to the 30th of November 2000?
I can't recall. I worked through the statement with each individual, and that would have been the case with Elaine Tagg, and worked through the documents with her. But that's as far as I can recall.
Going please to paragraph 12 of that statement, which is external page 8. Mrs. Wolstenholme persisted in telephoning the Horizon System Help Desk in relation to any problems which she had with the system, and generally, these problems related to the use and general operation of the system and were not technical problems relating to the system. Copies of the call logs for the period 10th of January 2000 and to 30th of November 2000, together with a brief analysis of the calls to the Horizon System Help Desk, which I prepared following Mrs. Wolstenholme's suspension, are at the pages 28 to 112 of EMT 1. Whilst there are some problems at other branches, they were not insurmountable and were often due to the system crashing or were general teething problems. At the time, did you have any concerns about the accuracy of Ms. Tagg's assessment of the type of problems which Mrs. Wolstenholme was reporting via the Horizon System Help Desk?
I don't recall that I did, because we were just acting on the information and instructions that we received from the client. And obviously the documents that were provided.
You refer in your statement for the inquiry to your involvement in the drafting of Keith Bain's witness statement. He was at the time a post office employee who held the role of contract manager with responsibility for contracts with Fujitsu services. That's right, isn't it?
Yes.
And he appears to have produced 2 witness statements for these proceedings, one dated the 14th of October 2003 and the second dated the 11th of August 2004, the second one being a matter of days before the trial date. Just to clarify, were you involved in the drafting of both of those statements?
Yes, I was involved in the drafting of both of them. And I think, as I mentioned in my statement, it would also have been the case that counsel was instructed to review and advise on the draft statements, as he would have been with Elaine Tagg's as well.
Just looking for now at the first of these statements, please. May we have on screen poll 00118250. If we can go over the page, please, to paragraph 5 of this statement. We see here the evidence: any faults that occurred in the Horizon computer system were eliminated once they were identified. Whilst it is possible for mistakes to occur, this is usually through incorrect inputting to the computer system in the office affected by the mistake. All sub-postmasters were fully trained in the use of the Horizon equipment. The system was fully tested before it was used by the post office, and it is fit for purpose. The system itself does not create losses, as is claimed by Mrs. Wolstenholme. What was the process by which Mr. Bain's first statement was drafted? Can you remember?
What do you mean by the process?
Did you take instructions over the telephone? Did you have a meeting? Did he send you a draft?
I would have either taken instructions over the telephone or face-to-face and then produced a draft, which we'd have amended and looked at over a period of time. I can't remember, is it in this statement or his other one where isn't there a query in the draft?
There is a version of this statement with a query in the draft.
Yeah.
Which we can turn up if you'd like us to. My question for the moment is about who else was involved in the process. So was anyone from Royal Mail Legal Services involved in this process?
With all the statements before they were finalised, everything went through my contact at Royal Mail. Well, it would have done that, so whether it's Jim Cruz or Mandy Talbot, and as I said, counsel would also be involved as well.
Were you told by Mr. Baines, or indeed anyone else from the post office, about the faults that occurred in the Horizon computer system that are referenced at that paragraph 5 when the statement was being drafted? Were you told what they were?
I can't remember.
Jason Coyne provided an opinion in the case in January 2004. May we have this on screen, please? It is WITN 002-10101. And that first page is the covering letter dated the 21st of January 2004, sent to you and copied to Mrs. Wolstenholme. We've been through this document in some detail this morning with Mr. Coyne, and I know you are familiar with it, so I don't intend to go over the report line by line, but just picking up on the key points. Going over to the second page, please. About halfway down. A little further down, please. Starting with the statement from Ms. Elaine Tagg. The statement from Ms. Elaine Tagg, the retail network manager of the Post Office Limited, at paragraph 11, stated that Mrs. Wolstenholme persisted in telephoning the Horizon System help desk in relation to any problems which she had with the system generally. These problems related to the use and general operation of the system and were not technical problems relating to the system. This, in my opinion, is not a true representation on the evidence that I have had access to. Of the 90 or so fault logs that I have reviewed, 63 of these are without doubt system-related failures. Only 13 could be considered as Mrs. Wolstenholme calling the wrong support help desk, requesting answers to "how do I" type training questions. Pausing there, did you find this assessment of Ms. Tagg's evidence by Mr. Coyne troubling at all?
Well, I would have done at the time, yes.
Did you raise it with Ms. Tagg or anyone else from the post office, as far as you can remember?
I don't remember specifically raising this, but I know that I certainly raised the concerns about the report itself, not only his opinion about Ms. Tagg's statement, but just generally.
Mr. Coyne goes on in the next paragraph. The majority of the system issues were screen locks, freezes, and blue screen errors, which are clearly not the fault of Mrs. Wolstenholme's making, but most probably due to faulty computer hardware, software, interfaces, or power. And over the page, please. About halfway down, we then have this. From the 31st of October, starting at call log number 102-53234, there seems to be a number of logs which talk of large discrepancies in stock figures, trial balances, with all sorts of figures showing minus figures. with another call log referenced. What was your reaction at the time to Mr. Coyne's opinion?
I was shocked and concerned.
And would you have sent this opinion from Mr. Coyne to your primary post office contact from Legal Services in the first instance?
Yes, I'd have sent it to Jim Cruz, I think at the time, would I? But yeah, I'd have sent it to my primary contact immediately, yeah.
May we have on screen, please, poll 00118249. This is an email from Jim Cruz to Keith Baines and others, copied to you, dated the 30th of January 2004. And we can see here you have previously had some involvement with this case in which losses at the above SPO are being blamed by the former SPM on the Horizon computer system being faulty and causing the losses. The case is before Blackpool County Court, and a computer expert Best Practice Group plc is the expert witness, and they have produced an opinion which concludes that the system was defective and the majority of errors noted in the fault logs could not be attributed to being Mrs. W's fault. This is clearly unhelpful to Paul's case. And then he asks, who would be the best person to see the opinion and comment on it, please? Would it need to be referred to Fujitsu itself? It may be that we can take up with the expert witness some of the matters referred to in the report and clarify them, or even persuade them that they are wrong, if this is possible. And turning over the page, please, we can see that Mr. Coyne's opinion was sent under cover of this email to its recipients. Being conscious of the time, sir, should we have a very short break now? I do hope still to finish my questioning by 2 o'clock when we need to finish for the day, but I'm conscious we've been going for some time. Just 5 minutes, sir. I think you may be on mute, sir.
I'm saying that I'm in your hands and 5 minutes is fine by me.
5 minutes then. Sir, can you see and hear us?
Yes, thank you.
We just had up on screen the document poll 00118249, the email from Jim Cruz to Keith Baines and others from the 30th of January 2004. Can you remember now what Mr. Cruz's immediate response to Mr. Coyne's opinion was?
I believe it was surprise and shock, similar to mine.
And did you think that Mr. Cruz's suggestion, if we can go back please to the first page of that document, that it may be that they could persuade the expert that he was wrong, was an appropriate one?
Sorry, could you just repeat that again?
Did you think that suggestion from Mr. Cruz, that it may be that they could persuade the expert that he was wrong, was an appropriate one?
No, but obviously I wasn't involved in the drafting of that email, but I certainly wouldn't have advised that be said, or that be that would ever be done.
May we have on screen, please, FUJ 001 21515. This is another email from Jim Cruz, this time dated the 24th of February 2004, and it's sending an attachment called Cleveleys' letter to Keith Baines and Colin Lenton-Smith. It is copied to you among a number of others. We have the letter which was attached. Could we have that on screen, please? It is FUJ 001 21512. And this is a letter from Colin Lenton Smith to Keith Baines, dated the 20th of February 2004. So scrolling down, please. You see the Colin Lenton Smith at the bottom there. And he explains that he's writing in response to Mr. Baines' letter of the 6th of February 2004, and note Post Office's concern in respect of the expert's opinion that the Horizon system installed at Cleveleys branch was defective, and that the HSH was more concerned with closing call than preventing recurrence of faults. An appendix is attached which sets out Fujitsu Services' view of and responses to the main points in the expert's report. In respect of the earlier correspondence between Jan Holmes, Fujitsu Services, and Jim Cruz, Post Office Limited, we would be prepared to discuss this further if it would help progress the situation. And going over the page, please, we can see an attached document entitled Appendix. Do you remember reading this document at the time?
Yes, I do now, having seen it, yes.
Just pausing there, you say at paragraph 17 of your statement to the inquiry that Peter Sewell asked Fujitsu to review Mr. Coyne's report. The reference you provided in your statement is to an email chain from August 2003, before Mr. Coyne's instruction. Is it right to understand that it was in fact Mr. Baines who asked Fujitsu, through Mr. Lenton Smith, to review Mr. Coyne's opinion?
Yes, it is right, yes.
May we have on screen, please, poll 001182221 at external page 236, please. This is a letter from you to Mr. Coyne, dated the 27th of February 2004. Was this you sending on the Fujitsu document entitled Appendix, containing comment on Mr. Coyne's opinion?
Yes, I believe it would have been that, yeah.
We have Mr. Coyne's response to Fujitsu's observations. Could we turn up, please, external page 57 within this bundle? Mr. Coyne's response came by email on the 2nd of March 2004. And we can see Mr. Coyne's conclusion over the page, please. Just above the best regards. In short, to answer the question posed in your letter, no, my opinion currently remains as stated in my original note. One of the reasons Mr. Coyne gave for the comparative figures from other branches provided in Fujitsu's appendix not changing his mind was that he had not been provided with the raw data. Do you know why the raw data from the comparison exercise was not provided to Mr. Coyne?
No, I don't, I'm afraid, no.
May we have on screen, please, FUJ 001 21534. This appears to be an email sent on the 3rd of March 2004 by your secretary, but sending on your comments about Mr. Coyne's response. Is that right?
Mm-hmm. Yes.
And those comments, you say the response to the initial report of Jason Coyne of Best Practice Group has been sent to him and his reply is attached. He has not taken on board any of the points made and has not revised his report at all. I would welcome any further points you have to make on his further report, but it seems to me that his report cannot be accepted by PO Limited and that an application needs to be made to the court for Fujitsu to give evidence about the Horizon system and its working in view of the stance taken by the expert witness. So was this your advice to the Post Office, that an application should be made for the Post Office to rely on evidence from Fujitsu about the Horizon system and its working?
To the best of my recollection, what would probably have happened is that the Post Office were being told one thing by the experts and something else by Fujitsu. So on the basis of the information that they were receiving from Fujitsu, then I would have said that on the basis of that, then we couldn't accept the report, and Fujitsu would need to therefore, like I say, give evidence, and then it would be a matter for the court to decide.
May we have on screen, please, FUJ 001 21567. This is an email from Jan Holmes to Jim Cruz, dated the 12th of March 2004, copied to Colin Lenton Smith. It doesn't appear that you were copied into this email, but I'd like to ask you about some of the observations made in it. Mr. Holmes gives his observations on Mr. Coyne's reply in the first sentence. We have reviewed Jason Coyne's reply to our paper and are disappointed that he was unable or unwilling to change any of his original opinions based on our original submission. He makes some further observations on Mr. Coyne's reply and explains that a further paper is attached, and then this in the penultimate sentence. We are happy to accommodate him at any or all of our locations and arrange such interviews and access to data that he requires, and would ask that you make this offer to him. May we have on screen, please, WITN 046 00206. This is the attachment to Mr. Holmes's email of the 12th of March. So you were asking about the date for this document earlier in relation to the evidence of another witness. It was attached to an email of the 12th of March 2004.
Thanks very much.
Were you provided with the email from Mr. Holmes or the attached response from Fujitsu that we see here at the time?
I don't remember seeing the email that you just showed me before. I can't say, but I would have been provided with this response.
About halfway down this page, there is a reference to a known error log, a KEL. And that's his statement, that paragraph starting his statement that the HSH. Did you understand what a KEL was at the time of your involvement in Cleveleys?
Gosh. I may have known at the time, but I can't recall.
If you had known that known error logs still existed, would you have considered those to be potentially disclosable documents?
If I'd have known that they existed, I would have said that they were disclosable documents, yes.
Were you aware at the time that Fujitsu had made an offer to Jim Cruz for forwarding to Mr. Coyne to accommodate Mr. Coyne at Fujitsu locations?
I don't know, I actually don't remember that at all.
May we have on screen, please, FUJ 001 21637. This is an email from Jan Holmes to Colin Lenton Smith, dated the 7th of June 2004. And we can see here that there's an account of a conversation with Mandy Talbot, and this was the document I was thinking of earlier, the reference to Jim Cruz's boss. The PM rejected the offer that was made to her some time ago, and a trial date has been set for August. I don't know exactly when. Poll are still taking advice as to how best to deal with this, and Mandy's belief was that the safest way to manage this is to throw money at it and to get a confidentiality agreement signed. She is not happy with the expert's report, as she considers it to be not well balanced and wants, if possible, to keep it out of the public domain. This is unlikely to happen if it goes to court. Is this description of Mandy Talbot's view of the case consistent with your recollection of the Post Office position at the time, that the safest way to manage this was to throw money at it and get a confidentiality agreement signed?
I don't ever recall having that discussion or even the reference to a confidentiality agreement. I don't think that was discussed with myself anyway. I don't think so.
Were you aware at all that it was a priority for the Post Office to keep Mr. Coyne's opinion about the Horizon system confidential?
I think I may not have been involved at this, I may not have known that at this stage, but then I've seen the advice that we got from our barrister, Stefan Lewinsky, an advice on evidence and quantum, and that talks about publicity. So if it was, it would have been referred to probably shortly after this or around the time of the conference with council that the Post Office were concerned about publicity.
Picking up then on that advice from council, may we have this on screen, please? The reference is Poll 00118229. May we have page 18 of this document, please? We can see here that the date of the document is the 26th of July 2004, so less than a month before the listed trial. Would you have drafted the instructions to council to advise on evidence and quantum?
Yes, I would have done.
Turning back, please, to page 3 and starting at paragraph 10. We have here the advice from council. Mrs. Wolstenholme has defended the proceedings, claiming that the computer system installed by the Post Office was defective, and this was, in fact, the cause of the losses recorded within her accounts. Further, Mrs. Wolstenholme puts the Post Office to strict proof of the losses it claims. Finally, Mrs. Wolstenholme counterclaims for damages in respect of wrongful termination of her contract, breach of her human rights, a claim under the Commercial Agents Council Directive Regulations 1993, a claim for breach of the implied term to provide a computer system fit for its purpose. At paragraph 11, the trial of this matter is now about 1 month away. A joint computer expert's report has been obtained. This report concludes, from the limited records available, that the computer system installed by the Post Office did appear defective. There is a very limited amount of documentation available in respect of the detail of calls made by Mrs. Wolstenholme and problems with her computer at the relevant time, as well as in relation to the errors and losses which built up in her Post Office records. This is because these records were destroyed about 18 months after events occurred. Recognising the weakness of its position, the Post Office has made a payment into court of £25,000. Over the page, please, to paragraph 14. We can see that council was advising on a number of matters, the first one being the Post Office claim against Mrs. Wolstenholme and the issues of evidence that it raised. Over the page again, please. We find the crux of the matter at paragraph 17. In view of the negative expert's report in this case regarding the computer system in place, Mrs. Wolstenholme's suggestion that the errors that arose were the result of defects in the computer system must be taken seriously. It is sufficient to place genuine and significant doubt on the evidence relied upon by the Post Office. In my opinion, to dispel that doubt and to persuade a court that its claim was justified, the Post Office would need to be able to produce to the court sufficient original evidence in support of its claim. It is unable to do so. I therefore conclude that the Post Office's claim against Mrs. Wolstenholme in respect of the losses on her account would be likely to fail. Over the page again, please, to paragraph 19. Further, for the Post Office to have a chance of succeeding in its monetary claim against Mrs. Wolstenholme, it would also need evidence of the following. 1, clear proof that the secondary evidence provided by the Post Office had to be or was extremely likely to be correct. 2, clear evidence that the computer problems reported by Mrs. Wolstenholme would not or could not have had any impact on the losses and figures contained within her accounting system. And 3, ideally clear evidence to counter the criticisms made by the computer expert in this case. Paragraph 20, on my understanding of this case, I do not anticipate that such evidence will be available. Then at paragraph 21, in relation to the claim for wrongful termination of Mrs. Wolstenholme's contract, given the lack of evidence in support of the Post Office's position on losses, and also the strong evidence suggestive of serious failures in the computer system installed at the Cleveleys premises, the suggestion that Mrs. Wolstenholme was in serious or repudiatory breach of her sub-postmaster agreement appears unsustainable. In the circumstances, there would appear not to have been grounds for summary termination of that contract. Accordingly, pursuant to paragraph 9(1)(m) of the contract, Mrs. Wolstenholme was entitled to a minimum of 3 months' notice on termination. Over the page, please, to paragraph 25. In the circumstances, Mrs. Wolstenholme's breach of notice claim appears likely to succeed. May we turn, please, to page 11 of this document, which is paragraph 37. A little further down. And this is dealing with Mrs. Wolstenholme's claim that there had been a breach of an implied term in respect of the computer. Mrs. Wolstenholme claims that there was a breach of an implied term that she be provided with a computer system that was fit for purpose. This term has not been admitted by the Post Office, and there is a case for arguing that any such term should only extend as far as the obligation to take reasonable steps to provide a computer system that was fit for purpose. The basis for implying either term would be that it was necessary for the purpose of giving the sub-postmaster contract business efficacy and or as representing the obvious but unexpressed intentions of the parties. Over the page, please. Counsel addresses a possible argument on the quantification of such a claim at paragraph 39, namely that Mrs. Wolstenholme's contract would never have been terminated were it not for the defects in the computer system. And then at paragraph 40, there is some advice on how to address this aspect of Mrs. Wolstenholme's claim. It is in relation to the possibility of such a claim being advanced by Mrs. Wolstenholme that the form of any implied term in respect of the computer system becomes important. If the term extended simply to the Post Office taking all reasonable steps to provide a computer system fit for its purpose, then the fact that the system provided may have been defective on occasion does not necessarily indicate a breach of this term. However, evidence would need to be adduced on behalf of the Post Office that reasonable steps were indeed taken. For this reason, I consider it would be advisable to seek to introduce, on behalf of the Post Office, further evidence setting out further detail as to support provided in respect of the computer system installed and attempts made to rectify defects identified. This evidence might be from an appropriate employee within the information technology part of the Post Office business and or from an appropriate employee from the suppliers of the computer system itself. Moving then to Council's conclusions, page 15 of this document, please. Paragraph 49 at the bottom of the page. On the basis of the above, it can be concluded that the Post Office claim against Mrs. Wolstenholme will fail, save for the return of the equipment which she has possibly retained. Her claim against the Post Office in respect of failure to give proper notice is likely to succeed. What is appropriate, the appropriate course of conduct in the circumstances, particularly given the desire of those instructing me and the Post Office to avoid, if possible, publication of the negative expert's report in the public arena. Just pausing there, the desire of those instructing me and the Post Office, who had expressed the view, as far as you can remember, that they wanted to avoid publication of the negative expert's report in the public arena?
The Post Office.
Can you remember who in particular now?
No, it would be whoever I was dealing with at that time.
What did you understand to lie behind this concern of the Post Office?
At the time, I can't remember I don't know what lay behind that, because I just knew from their point of view that they wouldn't want the adverse publicity of defects being shown in the system, in the Fujitsu, the Horizon system. But I don't remember. I can't remember anything more than that. I mean, I suppose it was already, Mrs. Wolstenholme had already brought a claim in the Employment Tribunal, it had gone to the EAT, and they probably just were concerned that adverse publicity would follow any decision of the court.
Did you share counsel's view that the Post Office's claim against Mrs. Wolstenholme will fail, save for the claim relating to the equipment retained?
The Post Office would have had a copy of that, of the advice, of counsel's advice.
Yes, but did you share counsel's view on the case, on the merits?
Did I share that with the Post Office?
Did you share that view? Did you agree with it?
Oh, yes, I did.
Would we be right to understand that the only aspect of the claim or counterclaim which counsel was advising should not be conceded was the claim for breach of the implied term that the computer system provided to Mrs. Wolstenholme would be fit for purpose?
Sorry, could you just repeat that, please?
We've been through a number of aspects of the claim. So the claim the Post Office brought against Mrs. Wolstenholme for the recovery of losses, the counterclaim relating to not giving notice of termination, and then the counterclaim relating to an alleged breach of an implied term that the computer system provided to Mrs. Wolstenholme should be fit for purpose. The counsel had addressed each of those, and in relation to the implied term point, seemed to be taking a slightly more nuanced view. So looking, please, at paragraph 51, in the circumstances, it seems that one method by which seems the Post Office might best achieve its objectives could be by making careful admissions within the court proceedings. This is a matter which I have discussed already with those instructing me, but I can set briefly out a possible approach. To illustrate, the Post Office could formally abandon its claim against Mrs. Wolstenholme and formally admit her claim of wrongful termination of her contract. The matter could then proceed to a more limited hearing to deal specifically with the remainder of her counterclaim. And just going over the page, please. At paragraph 54, the opportunity for taking these points will, of course, be the dates already listed for trial. The issues for the client and those instructing me are the additional evidence raised above and the question of how the trial should be approached. Again, I have already discussed this with my instructing solicitor. Having considered the matter further, my view is that the most appropriate course would be for these matters to be raised at trial following appropriate application having been made in respect of any further evidence and/or changes to the statement of case put forward by the Post Office. With careful case management, the issues identified could then be isolated at trial and dealt with as deemed fit by the trial judge. So the evidence that counsel was advising in relation to appears to relate to reasonable steps taken to produce a computer system that was fit for purpose, to deal with that implied term breach argument being made by Mrs. Wolstenholme.
Yes.
So my question is that the only aspect of the claim that counsel was advising should be continued with, that should be defended?
Yes, it does appear that that's the case, yes.
So was it in this context that counsel was suggesting further evidence should be obtained from the Post Office and Fujitsu?
Yes, to the best of my recollection, I think it would have been.
We know that Jan Holmes and Keith Baines both produced statements dated the 11th of August 2004, shortly before trial. And I think it's your evidence that you assisted with the drafting of those statements. Was that the point of these statements, to address reasonable steps taken by the Post Office to provide a computer system that was fit for purpose?
I believe so, but there's a reference to, we clearly had a conference with Stefan Lewinsky as well.
We can go to that. May we have on screen, please, WITN 04600310. We can see there's a list of attendees there, including you, Mandy Talbot, counsel, Jan Holmes and Keith Baines. And there are some notes with counsel's opinion on the case on the first page. Going over to the second page and the third page. We see about halfway down, SL cannot say there were no glitches. We'll be candid about that, but what did we do to help it?
Yes.
And then there's some discussion further down this page about evidence that might be obtained from POL or POA. And over the page again, to the last page, please. We see JH will take up with KB, turning info into witness statements. JH and KB liaise with SH. So is that you?
Yes.
SH agreed. So is that the background to you working on those statements with Jan Holmes and Keith Baines?
Yes, we'd have had received the advice from counsel and then had the conference on the basis of the advice which he gave to discuss it in more detail, and then as a consequence of this conference, then those statements would have been prepared.
Ms. Price, we're perilously close to 2 o'clock.
So I was just comparing notes with Mr. Blake. We are going to need to come back tomorrow, I'm afraid, sir. I don't have much more, but it will be another 5 or 10 minutes, and we are now nearly at 2 o'clock, I'm afraid. I apologise for not being able to keep to my time.
No, that's fine. Subject to anybody in the room thinking this is inappropriate, if you really are only 5 or 10 minutes away from finishing, then I would have no objection to the witness being asked to answer questions in writing to complete her evidence, rather than be dragged back tomorrow, unless, of course, she doesn't mind. If she doesn't mind, that's fine. But feel free to discuss that possibility, all right? I don't need to make a ruling about it. You can decide between you how best to proceed in these rather unfortunate circumstances.
So I think we have some questions on behalf of core participants, maybe about 20 minutes in total, as I understand, in addition to my 5 or 10 minutes. So we do have around half an hour of evidence left.
All right, that's fine. I'll say no more then. See you in the morning, 10 o'clock.